Oh, still carrying on. All right.
Two matters not reaching. Public.
But may I have permission to make a mention?
Yeah, sure, sure. Yes.
Well,
One,
yesterday-
1 minute. State GST.
Wherein, my lord, we are challenging
What do you
section 16.
Fresh filing or what?
We are challenging section 16 and 41 of state GST, my lord. Wherein our bank account of the company has been.
No. Fresh matter or fresh? When have you filed it?
Today we are going to file, my lord. And then-
Failing to file means at times we come across that it is not filed. This has happened in one case.
No, my lord, there is an.
We,
in the matter.
no. Mister, we have come across you first file it and then mention. First file it, get number and then. Because we have come across, we have granted a court slip saying that 4:30 it should come up. It was not filed.
To file it, my lord.
Don't we, this thing, yes.
Please.
Read and vacate was listed on 14/9. When the other side took time, may not start.
So, all right.
Any date may not.
30th October.
Very well.
Yes, madam.
The
Well,
interviews have to be commenced from.
Huh?
The petitioner has applied for the post of office subordinate in the Telangana judicial authority. And her post, and they had disqualified her for without any reasons, my lordship. SR has been numbered, my lordship. Kindly permit me
filed
to
it?
file. Yes, my lord.
So
Lunch
we'll
motion.
lunch tomorrow we will take. What is?
Tomorrow, the interviews are going to held from tomorrow.
We can hold a special interview for you. Don't you think that we have power to do so?
Okay.
We don't have
Tomorrow.
power to do so.
Till 27. Obliged.
The advantage is tomorrow
Well,
that we would have gone through the file, madam. And today the disadvantage is that we have to be dependent on you. Right?
Obliged.
Yes.
Will be posted.
Yes, Mr.
My lord, yesterday your lordship reserved one particular matter,
yes.
item number 31. At
Ah.
the end of the argument, my lord, the learned advocate
He said,
has passed on.
some Dharni portal.
Remember, that your lordship may kindly have a look, my lord. First page shows Patadar's name is the writ petitioner. Second page shows it is Sarkari land.
Huh? No, but he said that he will do it, right? You will do it. So you will make a change. That is the statement. All right, we'll take note of all this.
Yes.
Permit to make a lunch motion, writ of disposition, GHMC, Municipal Corporation.
Solid.
Filed it.
My lordships kindly. Not permitted by lunch motion. A writ petition is filed questioning the orders of the municipal commissioner. Not a past orders, my lord, without.
No,
my lord-
what fresh matter?
No, it's an writ appeal, my lord. He already filed yesterday.
Already filed. So we'll take it up tomorrow.
Obliged.
Yes.
I'm referring to the petitioner, Your Honor.
Heard on the question of, heard on IA 1 of 2023 and no, heard on IA 1 of 23 condonation in representation allowed, then heard on IA 2 of 23 issue.
Yes, Celia is unwell here.
Huh? Please tell her what, madam, did you get it? What order has been passed? Come here. Come. What order has been passed?
Condon delay has been,
Notice has been issued, right? So you should come up to argue these matters. Don't be dependent on your senior. Yes.
Okay, please, your lordships. IA 1 is delay in representation now, 67 days delay.
All right. Yes.
two,
delay in representation allowed, then same order issue.
the request is IA 3, which is seeking suspension, direction not to invoke the BG. The BG is expiring on 17/11, Manoj, bank guarantee. If that is
But
invoked,
what to do? There is an application for condonation of delay. Take steps, personal notice, do whatever.
shorter date, Manoj, subject to
Personal
lordship.
notice and proof of service.
Short date subject to lordship.
No, but you first serve them and then you can seek a mention, right?
Oblige, Manoj.
But in this similar matter, the order is passed, parties are one and the same.
Huh? What matter?
Commercial appeal, the same, parties are one and the same. There's an order passed in the earlier appeal filed by me.
Your petition under 34 has been dismissed, right?
Yes, my lord. 75% as per the MSME Act, it has been already deposited at the time of 34
Ah.
appeal. Out of that, 50% last time.
Learned counsel for this appeal. Record.
Wait. When an appeal comes up under 37 against an order refusing the relief under section 9.
Oh,
Look, the paper book is bulky only because the records below have been filed. It's a very thin issue. The learned judge is under the mistaken impression that an interim order passed whilst a previous appeal was before your lordships with asking for a security of 10 crores is sufficient. First, my lord, because the outgoing
what is the total amount?
90 today, 90 crores.
90 crores.
Now, my lord, there are two components to it. I have been refunded.
So what is this? You want an order of restraint?
Yes,
with
my lord. I
regard to
want
alienation.
some kind of security.
Alienation.
May I say
What
this,
is
my
it?
lord? 34 applications have already been, my lord, this application itself is based on the award, my lord. 34 applications have already been heard and reserved for the orders, my lord. My friend argued, and I have argued the matter as early than 24th September. But counter claims have also been given to us. And we will file counter, my lord, because this was the order. My lord,
You
which
know
was-
what we say, Mr. Reddy, that
my lord.
okay. What we are saying is that see, 34 objections have been heard, reserved for judgment. It
Yes.
may be reasonable. We can expect that a month's time it will be pronounced judgment.
My lord, already 20 days have elapsed, my lord.
Right. So why don't you this thing that you will not alienate for another 10 days? So what difference does it make?
No,
Are you really
I-
going to alienate the property?
My lord, there was no order, my lord, which was granted earlier.
Ah.
Now your lordships must see the reason.
No, with what we want, we will have to, we can adjudicate, but it's better to arrive at an amicable settlement, right? Till what we are saying is
No,
that
but
till till orders are passed on the petition under section 34, don't create.
Take instruction, so far as that
All
is
right.
concerned, conceding, I need to take
Yes,
instructions. Let it be posted to day after tomorrow,
All right.
Day after
Look, I
tomorrow,
was
I'll
just
take it.
making one submission.
Ah.
I was just making one submission. There is a important fact, since my learned seniors here, which will tilt the balance in my favor.
Hmm.
But Lord, I was given a decree of return of 30 crores and return of about another 9 to 10 crores.
Hmm.
Typically about 40. With interest today, it would come to about 90.
Hmm.
My learned friends on the other side were given a decree of 18.33 crores in their counterclaim.
Hmm.
My lord, my learned friends have fairly conceded that that was a patent illegality. Their contention, therefore, is that the entire award, qua me and qua them, has to go. Whereas my contention was the counterclaim has to go because it is a patent illegality and my award should be sustained. Now that my learned friends admit that there is no counterclaim to be had, the entire amount, even unless the award is set aside, the entire amount will be payable. And today the security I have is okay.
Depending upon the, what we are trying to say, that this is section 9, right?
Correct.
So now the petitions under section 34 have been heard
Yes, my lord.
and they are reserved for
Yes, my
order.
lord.
So
On
after
24th
it is
September.
one way or the other, if it is decided, thereafter you will have a right of appeal under either party. We don't know what would be the position.
May I say this,
That's why,
First round, there was a modification by the trial court under section 34. But both the parties have filed the appeal before
yeah,
this
but
round.
why you did not file this application under section, in the court before section 34?
I'm sorry, my lord.
Commercial court, you
did.
filed this application.
I did. That is,
So that is rejected. Oh,
It's been
rejected.
rejected on erroneous ground. My lord, there is one more fact.
This is 9 application.
No,
Ah,
this is
9.
37. The 9 was rejected.
9 was rejected.
Your lordships have asked saying that why have you not filed a miscellaneous application in 34? But this
He has filed you.
9 application.
He filed.
I did. My lord, there is one
So,
difficulty.
so now
Yes.
those proceedings, the final arguments have been heard, right? This order was passed on. You have come to this court after nearly 9 months, Mr.
My lord, the order
23rd
was made
January.
available. The order was made available. Your lordships will see at page 52 only in May. And thereafter,
So you find out, Mr.
my lord, there is
Your
one.
lordships were directed to be posted day after tomorrow.
All right.
My lord,
Let's-
that may not serve the purpose. I'll tell your lordships why. I will be able to show your lordships
All right.
from their
Issue heard on the question of
from their documents.
appeal is at. Without hearing in as you want. Second is we dismiss the appeal. Third is we admit or issue notice. We have opted for the third option. He is appearing. He has accepted notice. It will be heard.
May I make one submission?
Yes.
I bow down to the third. I bow down to the third.
Ah, yes.
I make one submission. I have shown through documents filed both before the learned commercial court and before your lordships that
There is no IEA, mister. We cannot
Correct.
grant any interim order. You are arguing for an interim order in the absence of any
I
IEA.
was asking for a short date for the hearing of the appeal.
They file an application for early hearing. That will be considered. Notice on behalf of respondents. Who is assisting you? Mr.
my
So-and-so.
friend,
Accepted by Mr. So-and-so. Yes. File an application. Yes.
I'll do that.
Yes.
I'm great.
Yes. Ah.
I,
On
9,
that.
10 and 11.
5, 9, 10.
10 and 11.
Yeah. We have already taken a view what to do, Mr. 5, 9,
10, 11.
11.
5,
Right.
5, 9, 10 and 11.
Okay.
Yes. Yes.
Similar matters were disposed of by this honorable court, my lord, by order date, my lord, Rashmi kindly tell.
Which
In
order?
this recommendation, passed.
Huh?
This honorable bench, my lord, passed earlier, my lord, the earlier occasion. The similar matters, where my lord, this,
Oh, this is what-
my lord, challenging, my
Great.
lord.
Mr. This is writ appeal, right?
Yes, yes, right.
Huh?
Also,
Leave a petition, condonation of delay.
my lord, without going into that, my lord, lordship was pleased to, my lord, order, my lord, pass orders.
Allowing the appeal.
Granting the liberty to, my lord, approach the, my lord, writ appellates to the, my lord,
All right.
learner single judge.
Yes,
challenging.
all right, yes.
Same order.
All right, thank you. Yes. Heard on IA one of the.
But I get to appear, my lord.
Yeah.
But against order dated
Huh.
10 July, where my learned judge, my lord, single judge, saying there is disputed question of facts, but refused to entertain. But there is no
But how this thing to vacate the property like Indian Oil Corporation?
The Honorable Supreme Court had held in such matters where the state
Writ
doesn't
petition lies.
lies. I filed a
We
judgment.
would like to see.
Yes.
Where is that?
My lord,
So all like no suit is required to be filed, everything,
State-
all government companies, state government,
it is
writ petition.
Yes, that's what.
I will,
And in fact, this
interesting.
court also-
We will like to see that.
My lord, lots will come to
One.
the dates, my lord, few days. The lease has been entered, it's not been disputed. 15 years lease is over. Subsequently, they did not invoke, my lord. But second entry, my lord, 18/6/2003, lease was entered. For 15 years, lease has come to an end. The lordship done overleaf. The rest of this, the lordship can skip, my lord. Second is, lease did enter. Second, overleaf, my lord. My lord, third, 1/6/2021. 1/6/2021, we issued a letter saying that please vacate the premises. Then, my lord, 14/7/2021. For the first time, they address a letter to for renewal, my lord. Overtake.
No, which is the judgment?
Yes. I filed
The writ petition can be filed seeking relief of possession.
Yes.
Is it not a contractual dispute, Mister? What is the
Contractual dispute.
dispute and what is the mode of 1 minute? What is the mode of resolution in the this thing provided in the agreement in case of dispute? What is the mode of resolution of
Well,
dispute?
no arbitration clause, my lord.
No arbitration. What does it? Let's see.
But
Where is the agreement?
And it is
And
at page number 46, my lord.
46.
Clause number 12 was relevant, my lord, for this at page number 57. They had to it. Clause number 12 at page number 57. They had to renew it before the expiry of the lease. So per se, there is no dispute resolution, therefore, my lord, the provisions of transfer of property may apply, my lord, that way.
Clause 12.
Clause 12 at page number 57, my lord.
Desirous of renewing. No dispute resolution.
No, there is no dispute resolution per se, my lord, such.
And where is the judgment of Supreme Court saying that suit for possession can be filed under Article 226?
Page, first is page number 69, my lord.
69.
Also, one in the case of Hindustan, let's say, identical oil corporation, my lord.
Sorry for interrupting, my lords. That judgment is referred to by the apex, by the learned single judge in her judgment.
Mhm.
In paragraph
He is appearing in your case.
For the respondent,
Yes,
madam.
ma'am. I'm appearing for the
Right, I am
respondent.
And we were also not aware.
I am not.
So, yes. Yes.
For the
So,
respondent, I'm
Mr.
sorry.
Fish.
Para 10, if your lordship sees the learned single.
Now, this is judgment, but page number 69.
Let him complete, mister, if you want to. You have filed a caveat, we will hear you also. Yes.
Well, this is a judgment where a similar kind of thing where eviction was sought under the oil corporation. The lordship may come to page 73. The contentions which were raised there, identical that disputed question of fact.
No, this thing.
But you not come to para
No,
number-
see, mister, that the Supreme Court has gone to the extent of saying that even in case of a disputed question of fact, the court can order recording of evidence and decide the writ petition. But the question is, this thing, a suit for possession can be filed under Article 226. That is the query.
Para 1, page 71, para 1.
Para 1.
It's under lease agreement where possession was.
You are sure that this judgment has not been reversed? Now, this was 99, 24 years.
Subject to correction because it's last minute. At least to the best of our knowledge, not been.
All.
Minute,
You are sure about it, right? We act
to the
upon.
best of my knowledge,
All right.
law is a ocean.
Call Rahul. Yes. This is a judgment which I have read as a lawyer with regard to delay and latches.
Yes.
Dolly Das
Dolly Das.
versus Hindustan Petroleum. We have read it on the principles of delay and latches.
And also the 226, that's also one of our judgment saying that 226 can interfere in contractual disputes also.
Yes.
And disputed question, that's where this judgment also.
So what? Yes.
No, but lease in a similar case, identical case, it was filed, it was entertained. That's para number 1 of page number 71, that's the lease agreement.
No, it was entertained. It's a different thing.
And entertained, I also first, you also asked me a query whether such a writ is maintainable. I'm saying that writ is maintainable.
Where Supreme Court has said?
No, but this was case arising under the same eviction position matter. Your lordship may come.
1 minute.
I'll have to your lordship notice that.
Yes. Why they see para 1 itself, you will this thing find out that the lease in this case had a statutory flavor in the sense that under the provisions of the act.
Yes, sir. Subsequently, the amalgamated, my lord. In para number 2, the 226 was invoked on extraordinary jurisdiction, para number 2. Questioning those release, my lord. Your lordship, para 2, 1, 2, 3, my lord. This was
The
challenged.
dispute with regard to renewal.
Yes, but now this is the same thing, my lord. Dispute
No,
enactment.
this is you are seeking the relief of possession, Mr.
No, but their content is renewable. We said it's not renewable.
1 minute.
See, positional.
We have, I think we, yes, the relief is for possession in your writ petition. See, therefore issue a writ to vacate scheduled property.
Yeah, because their content is renewed. I said it's not renewed, therefore, vacate. I'm seeking for positional limit.
Also seeking possession.
Seeking positional limit.
Here the case was of this thing renewal.
No, but there also, my lord. There also they sought for a positional limit in this case also. Dolly does also the question. By questioning the renewal. They also sought for a.
Also, where it is said that it is if instrumentality or this thing, a writ petition seeking the relief of possession is maintainable.
Para number 2 is for same thing, where the reliefs have been sought.
Proposition. A proposition.
Proposition will saying that position has been.
See 99 volume 4 SCC 450. Whether it's still this thing, has it been subsequently considered or reconsidered, distinguished or overruled? Please tell. Yes. Yes.
But the relief has been granted in para 12. Where they have been.
No, they may have granted, but the question is, we are asking you a legal
Proposition will can be filed for seeking recovery of position. That's what your lordship.
Yes.
That's why I think that's precise.
Yes.
Right?
Yes.
I'm only saying that there's a prayer here also for recovery of position only sense. Article 2, that's what para 2, my lord. Para 2 was, after reading your lordship, I read para 1, after the expiry of fees. Letter dated 23/79.
It will be governed by transfer of property
Yes,
act. You
one
have
outside,
to
one
give a
inside.
notice and terminate the this thing, and he is a tenant holding over.
But I have,
And ideally speaking, I mean, Indian Oil, you are a public sector undertaking. Huh? What you should do, ideally speaking, getting into litigation like a tenant.
My lords, we had in fact, in exercise of the said power, I'm assuming the question is to us, my lords.
Yes, the council, you are appearing.
Exercise of-
Uh,
Yes,
uh,
in exercise of the said power.
no, we are not on merits. We said that you are in public sector undertaking, Indian Oil Corporation. I mean, you could very well seek instructions if there is like possibility of some amicable settlement, if you want some time for vacation of.
I'll find out, my lords. I will definitely find out.
That's what,
I will definitely
apart
find
from,
out.
otherwise we will, because it's Indian Oil Corporation.
Yes, I see where your lordships are coming.
They are
from.
very good tenants and good people.
Yeah, immediately after the vacation your lordship may have, I will talk to them and get instructions.
Right? Apart from this, you find out which case.
yes, well, that's subject.
Yes. In
I will
this
do
inter-
I will also tell them,
Huh?
I will convey your lordship's sensitivity to them, my lords.
uh,
1C
uh,
657.
657. See, Mr. 2014 Volume 1 SCC 657. This has been explained. You may find out what is it.
Yes,
There
ma'am.
is also 2021 Supreme Court,
Huh?
SCC, 2021 SCC,
Huh?
562, Subhash.
2021?
Which
What?
2021 SCC, online, page 562, which is referred to by the learned single judge.
No, we are asking whether this law laid down there in 299 decision is still a good law.
In response to that, the learned single judge referred to a contra view of the apex court on where there are disputed questions of fact.
No, we are not on. Mr. We are not on disputed question of fact. Probably our system is not working properly. That means you are unable to hear us. We have been asking him in a suit for whether you can seek the relief of possession in a writ petition under Article 226. That is the query.
My lords,
And 99.
judgment,
No,
in
so we are not.
judgment itself, para
Mr.
9 answers your question.
No,
I'm
if
sorry,
you
my
want
lords,
to,
para
then
9
all right, Mr. So all right, then let him argue. Then if you are arguing the matter, we just
I'm not arguing.
like
I
yes,
will go
Mr.
back to the
Venkatesh.
IOCL. My lords,
Then argue.
I think this non-clarity, I'll just confirm. I will go back to IOCL, convey to them what your lordship said and come back to your lordships.
See, every litigation need not be contested. In every case, no, it's not necessary that SLP should be necessarily filed. That's why mediation and this thing, and especially you are this thing.
We'll find out. I'll find out and come back to your lordships. I'll find out and come back to your lordships.
This intra-court appeal is filed against an Or probably he has some difficulties, 31st of October.
November, any date, Your Lordship?
We'll fix it for November then,
Yes, my lord, Your Lordship.
6th November.
Apply.
May please, Your Lordship, appearing for the appellant GHMC in this matter, my lord. Lord, there is a IA number 1 is a delay
Before
of
my friend begins, my lord, may I?
Continuation of delay also you
delay
want?
of 127 days. IA number 1.
My, AR would like to file a counter and then one more submission. Not as against the very same impugned order, her intra-court appeal was filed which was dismissed. And the GHMC was the party.
Mr.
Yes, my lord. There,
393 of the paper book.
yes, sir. The implead applicant, my lord, before the learned single judge has filed that appeal, my lord.
Correct,
Sir,
but
page number.
what can be done? And see, Mr. Your remedies,
Yes,
though we are not supposed to do it, but we do it also to tell you what is your remedy.
no, my lord.
Remedy is to file vacate petition in WP 20621 of 17. Because that is the basis of passing an order. He says that even though the allegation is that it has been obtained by fraud and forging signature, but there is a stay. So that's why the reasoning is that so long as the order, if an building order cancelling building permission is suspended, the building permission is valid on account of that interim order. That is the basis for grant of an interim order in this case. So remedy is to apply for vacation and then seek modification of this order. Instead of it, you are pursuing a wrong remedy. And that too, see, we can't take a different this thing, no? Page 393C. Whosoever is filed, but the order passed by learned single, 1 minute.
Yes.
Can it be that in one appeal, the validity of the order is upheld, in another appeal, it is set aside? Merely because it is filed by GHMC, that we can't do. Please see. This is the order, you know.
Yes, ma'am. Page number
Yeah,
398 is the
and
last.
principle of parity applies, right? We have to maintain consistency.
Lordship may grant liberty to file the.
That's what you should do.
Yes.
Third on IA number so and so, 1 of 23. Application seeking condonation, reasons assigned.
timeline to decide, my lord,
Huh?
as expeditious.
First file.
Yes.
I'm obliged.
This was item 8, right?
May I please, Lordships?
12.
In pursuant to the notification, my lord, I filed notification at page 20. They issued
Huh?
my lord notification on 25/9, my lord.
Huh?
And I made application, my lord, on
Hmm?
20
No, what?
for UG Ayush, my lord, admission into UG Ayush. My lord, the notification at page 20. My lord, they permitted to, my lord, make applications, my lord,
Date.
25/9/2023. My lord, they are permitted to make applications, my lord, from 26 to 210. My lord, the petitioner made application, my lord, on 28/9/2023. And the same was, my lord, not considered, and merit list was issued, my lord, by the second respondent on 5/10/2023. My lord, showing the petitioner, my lord, as non-local. Page 15, my lord, I filed. And my name, my lord, shown at page 17, my lord, from bottom, my lord, 14 line. My lord,
What is it, Mr. Rao? What is the case?
The petitioner, my lord, studied from 1 to 10.
No. He has applied for UG Ayush
Yes, lordship.
under Ayush course.
Ayush course.
BAMS.
BAMS.
So when was the notification issued?
Lord, 29 lordships.
29th,
Lord, 29/8/2020.
29/8/23.
Lord, he was.
And no, he's saying 25/9/23.
page 20, my lord, I filed the notification also.
No, that's. When was the notification issued inviting application, Mr. Page 20?
Page 20, my lord, this, all the notifications, my lord, I filed.
25/9, Lord. 25/9.
25.
Lord, he was declared as a non-local, my lord, by merit, in the merit list, my lord, published on 5/10/2020.
5/10/23 declared non-local.
Because the petitioner studied intermediate, my lord, Maharashtra, Pune,
One. Non-local. So class 1 to 10 where?
my lord, Telangana.
Telangana. And
And my lord, the intermediate, my lord, Pune, my lord.
Pune. All.
But he taking parity of my lord, your lordship's judgment. But as earlier, my friend filed a writ petition in which my lord, he has shown a residency certificate having only 1 year residence. Then he withdrew the my lord, the writ petition and filed a fresh writ petition now.
So where is the residence certificate, Mr.?
Page 31, my lord.
You got it right this time.
Yes, in a format, my lord, I got it. I stated so, my lord, paragraph 12 of my affidavit, my lord, that earlier, my lord, the same was not furnished to me. So therefore, my lord, being the latest one, my lord, I filed that.
What do you say, Mr. Rao?
Consider.
No,
The
because
residency certificate is a different format. my lord. Earlier, my lord, this was not the.
where is this?
No, the Tehsildar is empowered to give certificate like this because see, para 2. What is the authorization?
This is the format, my lord. I filed the format. along.
Format he has given in terms of Andhra Pradesh Education Institution so and so. Is he empowered to give a certificate like this?
We will say that subject to
But it has nothing to do with my lord, the eligible.
admission. Otherwise, Tehsildar would be deciding like super authority
Yes, sir.
and telling us what to do, what not to do. Can't be. We will say that you consider his this thing subject to that he produces a residence certificate.
Yes, obliged. Yes, lordship.
Not available in the next round of counseling.
Next round. Obviously, next round. What can be done?
I informed my lord, counseling yet to be started, my lord, my information.
Who knows better?
Yes, of course.
The council
Yes,
for
yes.
university, right? We
Yes,
also don't know because we don't hold counseling. We don't run any college where BAMS courses, this education is imparted. You also don't have a college. So when, how do you know when? He's telling, no? Yes, Mr. Rao is very fair, Mr. He has considered that he'll consider you in the next round of council.
Yes, obliged.
We know that. That's why we ask him, what is your case? So we know that he will tell us correctly. When this court asks a question to the other counsel, what is petitioner's case? That shows that the court has faith in the other person that he will state correct facts. And we have tested it. It's not that it is I have spent 3 months. Thereafter, we are telling you this. Petition is admitted. That's what, Mr. While drafting the petition, you have to be cautious, right? Don't see, we other day when you were arguing, you were dismissing. See, this is how drafting.
We come up. Much obliged.
It may help you.
May it please your lordships.
Yes.
This petition before your lordship is challenging the action of the respondent number 2 in converting the seat reserved for PWD category into general category without in violation of the conversion algorithm given by the need counseling scheme, my lords. The petitioner,
Which seats have been converted? You are a PWD candidate?
PWD candidate, my lords.
Ah.
I've completed my
Your this thing has, your seat has been
converted, my lords.
And my submission lordship says, my lord, the petitioner was not qualified when the notification was issued. The petitioner secured 294 marks. The qualifying marks is 290. Where the university conducted
290
290.
and he has secured
274. Where subsequently
One minute.
NMC reduced the qualifying marks to 0 lordships, 0. Then he became eligible. A notification was issued after completing the 2 rounds, my lord. Then he filed an application, he was enrolled. By then,
find out what is the case, find out, like you may be required to file this thing, no, saying that you are converting, is it correct?
already, after, as usual, my lord, after second round of counseling, the seats, PWD seats were, left out seats were converted and we were allotted to various candidates.
My lordships, my humble.
All rounds,
One minute, we will hear you, it can't be decided with, we are just trying to understand, Mr. You are also just groping in the map by saying all this, it is being converted. If we ask details, you won't be able to tell us.
petition could have been.
That's why we are trying to understand. You have seen earlier petition, how he, when he speaks, he may speak for your benefit. So that's why we are hearing you. The approach is, we are open, not that we want to dismiss your petition. Don't get that impression.
No.
We are just trying to understand what is, are you, sit down, Mr. Rao, why should you trouble yourself? Let him make out his case. Yes. So, how many seats were there? How, when the examination was upheld? NEET PG examination. When was the examination held?
Lordship. Examination was held in the month of August, my lord. And my name in the third list of counseling, you lord, if you lord, the 93 page.
No,
90
August 23 examination and when? All right. So how many marks did you secure?
I secured 136.
When was the result declared?
I'm telling you, lord. Thank God. I'm
Then tell.
page number 107, my lord.
No, not 107. Date. You please always remember you are here to assist us, not to tell page numbers. Otherwise, we sit down, you sit down, we will look from 1 to how many pages? 105, 110 and
I
find
secured
out.
139 marks, my lord. I'm just referring to the document, your lordship, sir.
Don't, I mean, we have full faith in you. You are an officer of the court. Why would you tell a lie? So we don't want you. Tell us the facts. When was the examination held? When the result was declared? When they converted the seats? How did you know? What is the source of your knowledge that these seats have been, how many seats have been converted? Who has been given admission? Please tell.
Seat matrix has been issued, my lord. It's a third notification.
Date of examination, result.
Date of examination.
It has a bearing, Mr.
My lord.
It's everything. You should tell us. If you are not ready, we will take it up tomorrow. You get ready. If you are not ready with the facts.
I'll argue tomorrow, my lord. If your lordship pleases, I'll argue tomorrow.
No, pleases means we are ready. You should tell when the examination was held. You are turning pages.
No, my lord. 5th of March 2023 examination was held.
You said August. Then now you have March. Like
my lord, sincerest apologies, my lord. I'll argue tomorrow, my lord.
Not ready, right? No, you say not ready says.
I'll prepare my notes, my lord.
Learned counsel for the petitioner prays for adjournment.
Matter pertains to the pre-appeal deposit required for TREAT appeal, my lords. My lords, the impugned order has been placed in page number 55-56, my lords. This is dated 10/7/2023, my lords. But a few brief facts are required to be submitted before your lordships. My lords, when the order dated 13th February 2023 passed by TREAT Kolkata was challenged in WP number 7871 of
You
2023.
tell us the facts first.
My lord?
Few facts.
That is what I'm
Which
telling.
DRT order? 3rd July.
12th July 2023. my lord.
Why DRT passed that order?
That is why I'm coming. Just few facts.
No, we have read it, but since you want to tell the facts, so therefore we are asking you.
Yes, my
So
lord.
what?
When the DRAT,
Why
I have
DRT?
appealed for DRAT, my lords, and DRAT passed an order on 13 February 23.
You are a borrower.
Yes, my lords, and petitioner borrower.
Borrower. So what was done? So
My lord,
being under 13 initiated.
after losing the case before the DRT, Hyderabad, in respect of
Losing
sale,
case means proceeding under 13 was initiated.
13 for हो गया, sale notice भी हो गया, sale भी हो गया, my lords. Sale भी, already after sales.
Sale.
No, the
So
point
you
is
can-
coming, 11 crores prescribed is on court.
No, no,
I'm
you are,
going.
Mister, you are insisting on telling facts. We are hearing you. So you will have to tell complete facts, right? Not like this.
But
Whatever you want to say.
Well,
Please tell us.
sale notice,
One minute. 13-4 notice was issued. You challenge that in a proceeding under section
not
17.
13 for my lords. This sale, certificate of sale, my lords.
Ah,
20th May 2021 was the certificate of sale issued, my lords.
yes.
So the proceedings started from e-auction sale notice dated.
No, that's correct. So what you challenge the under section 17?
Yes, my lords.
Ah.
And before DRT.
What happened?
So my lords, certificate of sale was issued and
What DRT? What did they do?
they has been dismissed our appeal, my lords.
When order date? Order passed by DRT.
My lords, this I have kept in file, page number 23 to 37.
No, no, you tell us the date, mister.
Date is 5/8/2022.
Appeal dismissed. Your application dismissed. Ah,
Then the matter carried over to DRAT,
DRAT.
Kolkata.
what happened?
Compulsorily there should be a pre-appeal deposit.
No. Order date DRAT when it passed an order.
No, that is what I am coming, minutes. So for 10/7/2023, sorry, 13 to 2023, the DRAT Kolkata passed the order, my lords. This I have placed in 38, page 38 to 41, my lords.
Ah.
My lords, the DRAT prescribed some amount around 24 crores as pre-appeal deposit. Based on the oral updated claim submitted orally by the blank, my lords. In fact, it was not based on sale certificate. So aggrieved by the order dated 13 to 2023 passed by the Honorable DRAT Kolkata. The petitioner approached this Honorable Court under writ petition number 7871 of 2023, my lords. My lords, this Honorable Court passed an order on 23 March 23. I have placed this order on in page number 42 to 45, my lords. It directed 11 crores within 1 week to show the bona fides and while staying the order dated 13 to 2023 passed by DRAT Kolkata, my lords. But the issue is here. Before 31/3/2023, the petitioner could not deposit the entire amount. He could mobilize the amount.
Your remedy is, according to us, your remedy is to seek modification of the order passed by this court. DRT.
Modification is only allotment of time, my lords.
That is what you should do. DRAT is bound by the order. DRAT.
My recall letter has been submitted, dismissed just because the Honorable
High Court.
could not go beyond
Then you should seek enlargement of time in the order dated 20th/3 on the ground that I have deposited the amount. So therefore, please explain to that. Anybody will do like, but you should seek appropriate remedy. This order we can't interfere. So you will be well advised to file an application for enlargement of time in this 7871.
Because as the matter is already
All right.
disposed.
You are limited to argue.
Because it is again gone as a recall order before the DRAT. Well, I have approached the petition, my lords, on 226.
No, WP, this order was passed. Now he is saying he filed an application for enlargement with the DRA. That is rejected, obviously it will reject, no? Because it is bound by the High Court. Instead of seeking that modification, you challenging the order passed by DRAT.
My humble submission before the honorable court is, I require the honorable court's approval in respect of payment of 7 crore immediately, so that the matter will be
We
removed.
don't approve anybody's action. We don't approve anybody's action. We decide the case brought before us in accordance with law. To the best of our ability.
Mobilizing.
Why, I mean like, why should you seek our approval? You have not taken loan with our approval.
Because the DRAT cannot go beyond the order of this honorable court, my lords.
So what is your remedy?
They are,
What can be done?
so that is the reason, after going to recall again, I have to come for petition, my lords. Otherwise, I would have, because when there was an IA pending for extension of the time, it was not disposed of till the matter was, what happened, my lords? On 10/7/2023, the this appeal and the pre-appeal were dismissed, were non-compliant of the order, not only of the High Court, but also of the DRAT. Because this honorable court dismissed writ petition 7871 of 2023 on 12th July, just because the DRAT already dismissed the appeal. But that is how I am clutching between these aspects, my lords. One thing, my mistake is that I have belatedly paid the amount after this honorable court. And by 10/7/2023, as it was not complied with, the honorable DRAT dismissed the appeal before it. Whereas because the honorable DRAT dismissed the appeal before it on 10/7/2023, this honorable court dismissed the writ petition 7871 of 2023 on 12/7/2023. So it happened like this. Technically, because of the dismissal, this was dismissed. So I approached through recall order, my lords. So my point is, my lords, I have genuinely, without looking into the equities and the bona fides of the petitioner, my lords, the writ petition was dismissed. So my humble submission is that, my lords, the honorable court has to enlarge the time.
Yes.
So while I have good merits in my appeal, my lords, because of this problem of mobilizing 11 crores, because, my lords, within 1 week, mobilizing 11 crores could not be possible, my lords. And hence it was belatedly done.
Remedies to seek modification of the order in writ petition.
Sir, your remedy lies in seeking modification in the writ petition.
My lords,
Your remedy would lie if you seek a modification in the writ petition.
We cannot set aside the order passed by DRAT because it is the order of this court is binding on DRAT. That's what we are repeatedly telling you, Mr. We are repeatedly telling you your remedy lies in seeking enlargement of time in the order in WP 7871. So once the court enlarges the time, the DRAT will obviously be bound by that order. You have already paid the amount.
yes,
But we cannot set aside, there is nothing wrong with the order dated 10/7/2023 passed by DRAT because it is in consonance with the direction of this court.
actually,
Please understand.
also about the merits of my case, and I said that unless you modify the order.
Then why instead of seeking modification, why have you filed this writ petition?
Well,
That's what we are trying to tell.
Finally, because the matter was already closed during July, I thought my remedy must be lying in it. So, my lords, I leave it to your lordships. If it is not possible in this writ, I will file a modification application.
It's obviously not possible.
My lords,
You understand, right?
that's up.
How can we, this thing, set aside an order which is in consonance with an order passed by division bench of this court? That order also binds us.
My lords,
Coordinate them, right? We don't have any greater, huh?
I will move appropriate application.
So, shall we say you will withdraw with the liberty?
Yeah, my lords,
You will withdraw with the liberty or we pass an order on merits?
the liberty or
Yes,
the liberty to file the modification.
yes. In this writ petition, the petition. After arguing the matter to some extent, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition with the liberty to seek modification of the order dated 20th March 2023, passed in WP number 7871/2023. Paragraph: in view of aforesaid submission, the petition is disposed of in terms of liberty as prayed for. Yes.
Well, it's a appropriate application, liberty.
Liberty is given.
Oh, much of it.
I kindly permit for withdrawal of the petition.
Seeks leave of this court to withdraw for the.
I may be
Any
permitted to
objection?
withdraw, Lordship.
Any objection? Learned counsel for the petitioner has filed a memo seeking leave of the court to withdraw the writ petition. The aforesaid memo is taken on record. In the result, petition is dismissed as withdrawn. Same memos. 16 also same order, madam. Same order, withdrawal.
But in this minute, I filed an application for IA, 1 of 2023. Not bringing your lordship's notice, there is a pendency of the cases, not against third respondent from since 2012 onwards.
Mr. But that's correct. What we have, this thing on the last date of hearing, we had, these facts have to be incorporated by way of amendment, right, in para 5.
Yes, my lord.
Have you filed the application for amendment?
Yes, my lord.
Where is that?
IA.
IA, which IA 1 of 23?
What? Let me kindly have a look at page 7 minutes.
7.
7 is the order passed by your lordship's minute. Rendered counsel for petitioner placed for but granted 4 weeks time to enable him.
That's what we are. So where is the amendment petition?
IA 1 is.
What is it, the incorporation, this you want? Amendment to be incorporated, what is it?
Is to permit the petitioner to incorporate the documents annexed here with serial number 4 to 14 in para 8 of the contents of the writ petition.
There is no this thing, right? You only want to incorporate. There has to be an averment.
But that averment is specifically stated in the affidavit.
We have no problem, Mr. But these documents will be incorporated without any pleading.
No,
you have to.
Statement in the affidavit itself.
Not in the affidavit, sir. You have to make amendments. In the amendments, you have to specifically plead how these documents are just and necessary.
You are just seeking by way of amendment incorporation of documents. Tell brother.
But I specifically stated in the para 4 and para 4 of the affidavit.
All right, what can we do? We will allow this amendment. What, I mean, you are not getting it right. Like, will you help us, Mr. Senior Counsel? Please stand up. Will you help him? See, what he has done is, he has filed a petition.
I understood, madam.
Now, we at last date of hearing, we said that to make an application for amendment and to produce the documents in support of that. So, he has filed an application for amendment. By proposed amendment, he is only incorporating documents as annexure so and so. So, whatever annexures are there, there is no pleading in the petition with regard to that. We are trying to make him understand. We have no problem. We will allow the amendment. There is no, but
it won't satisfy its purpose.
Because he has to plead those facts that how these documents are relevant, how the trial has been delayed, what this all facts are missing. But it's not our job to make him understand. It's his petition, but if you can please explain it to him, fine. Otherwise, we allow the amendment. The documents are being incorporated in the petition without there being any pleading. The other side will, if we issue notice, other side, what objection they will take, you know better. Right?
Documents have to be supported by pleadings.
That's what, please explain to your friend. That's what we are trying. See, Mr.
Yes.
We are not this thing, we are not against you for anything. We would have quietly allowed the application and notice, supposing if we issue notice, they will take an objection. There is no pleading with regard to these documents. You understand what is your basic grievance? Your grievance is that against respondent number 3, the proceeding should be expeditiously concluded in view of law laid down by Supreme Court. This is the relief you are seeking. For that, antecedents fact should be that the matters are pending, no progress is being made for one reason or the other. These documents support my case that the proceedings are being. This what you should say in paragraph 5, elaborate it, paragraph 2, 3 at paragraphs and annex those documents. We feel as if we have never left practice, still telling people what to opinion, giving opinion, telling what is the remedy and how to plead and prove this thing. All we are telling this. So you will file a fresh petition.
File a fresh application,
Yes.
If the application pending, I will file
A fresh application. You file along with those documents, making a pleading. Understood?
That meanwhile, that's the reason to number the bill,
It will be numbered. What's there? It will be numbered. You file first. We will number. Learn it. How much? 2 weeks?
2 weeks.
Learn it counsel for the petitioner praise for
What counter will?
Yes. I remember that one CD. This.
No, so madam, what? No, the petition has not been registered as yet. We have not issued notice. You do whatever you want to do. We can't prevent anybody. You have not filed a caveat. Notice has not been issued. And you are telling us that you are appearing. So appear. We are not preventing. Your presence will be marked. You are appearing on advance notice. What? How you are appearing? Advance notice. Write her name. You, madam, don't expect us now to explain what order we have passed. Huh? Please do not expect us. This is too much that you people file a petition, we explain to the petitioner, then to respondent. It's not our job, madam. Do whatever you want to. We are not preventing you from appearing. Do whatever you want. Advise your colleagues, Mr. Praveen Kumar, what to do. The public interest litigation has not been registered. That's his submission. We are asking him to make an amendment. Please, what to do? Tell us.
It's a very short case, Manoj. It's a commercial appeal under the
I'll take 5 minutes.
It's a
yes.
It's a commercial appeal under the Copyright Act, my lord. My lord, we have filed a synopsis, a 2-page synopsis.
So what time? We will hear it after vacation, Mr.
But the only urgency, my lord, is that medical students are not getting this case concerns.
Let them enjoy Dasara vacation. Thereafter, they will read the books. So, why who know?
But the problem, my lord, is that as the lordship knows, physiology is a fundamental subject for every student. Now, every MBBS student has to read. the latest developments.
All right, is that urgent? We will hear it today at the end of motion hearing cases then. Is that urgent? We will hear.
Lordship may have it on after vacation because there is another here, there's a 2:30
Okay.
another judges fixed a matter.
All right.
That's the only.
No.
The Lordship may do it, may request the Lordships after reopening the first,
Yes, what date?
whatever date after convenient. for you.
31st, 30th, whatever.
2nd November, if I may request, my lords, 3 days, some arbitration matter is there. as well.
2nd November.
Subject to continuous.
2nd November is all right. Yes.
On that day,
Ah,
the request that we
list.
will conclude the matter.
Given the synopsis, right?
Only 4 dates are there.
Fine,
4
fine.
dates.
Oh, we are also ready. We could have dictated, but we don't want to pass an order before vacation. We could have decided it today. We are also subject to hearing both of you.
I also
We know.
circulated a synopsis.
Yes. 2nd November.
platelets. This is again a millet's commercial appeal under section 37 of Arbitration and Conciliation Act. And
All right. Appeal is admitted for hearing records.
let's only respectful submission that during the entire the section 34 proceeding.
You want to file a counter to the IA. Let him file counter to IA, then we will consider.
We file a counter. Counter is also
One
filed.
respectful submission, I have nothing
Give
else
the
to
file.
say. Even Millets, when this.
What IA? Your objection under 34 has been rejected. What is the amount of award, Mr.?
Well, today, as on today, they have to pay 350 crores. 350 crores.
350 crores. And I am Millets Hyderabad Municipal Development Authority Millets. And they had not pressed even during section 34 until now. Till the
So what you want stay of recovery of 350 crores? That we won't grant.
I'm not saying that. What I say is this, on the last date of hearing before the predecessor bench, what was Millets agreed by the parties was that Millets, this matter will be heard Millets in one
Because the parties agree, that doesn't bind the court, right?
No. Millets, what it was observed by the court that parties will argue this matter in one go. There will be no separate Millets arguments on the interim application. Until that time, they will not press the execution. It is coming up on 31st. So that's the problem. And otherwise, I am ready to argue.
Well, it is not recorded anywhere, the order sheet.
It was not recorded. I must bow down to that. It's not recorded.
Mr. Anything transpired in a court, provided my lord is a party, brother is a party, fine. I was definitely not there. And he is also not a party. So how you can tell?
In fact, Millets, it was.
So you argue your application for a stay, Mr.
Yes.
Want an order.
Millets, may I say this? This is in Millets,
You have filed counter ready, Mr. Venkatesh? Yes. So what was the award passed?
Millets, the award is for payment of 3.5 NVTs. These were the payments which were to be made to the Millets, the concessionaire, the respondent here. NVTs were to be paid Millets as per the Millets terms of the contract. However, Millets, may I give 3-4 dates and then Millets, I come to the relevant provision of the contract Millets that may probably Millets answer the issue Millets so far as this interim is concerned Millets.
You want stay of recovery of the amount against you, right? In entirety.
I say till the time Millets are able to hear us or Millets are allowing us to argue, till that time let them not press. And I would say reason is this.
No, we can't ask them not to press, supposing he want to.
already
If he agrees, if your friend agrees, you convince him. If he agrees, we have no objection. But if you are asking for an order, we will have to deal. It's a money decree, Mr. Plain and simple. With your experience, you know at the bar what is the usual order we pass.
But only one.
Still, we are hearing you.
Yes.
All right.
Only one respectful submission, Millets. I am Millets Hyderabad Municipal Development Authority. I am here, Millets. I am not running away, Millets. I am one order away. And I can anytime, Millets, come and comply with Millets' order. It is a public money, Millets, which is being used for some public purpose. my respectful submission is this award is in the teeth of express provision of the concession agreement, it's the contract, and the clause 6.2F of the contract very categorically says that so far as concessionaire, the contractor is concerned, he will not be paid any annuity. Miller's, this is Miller's BOT, Miller's Build, Operate, Transfer, Miller's concession agreement, under which Miller's they had to construct this particular portion of the outer ring road within 2.5 years, and thereafter Miller's they had to maintain this expressway Miller's that stretch for another 12.5 years. Against that construction as well as the maintenance.
We have admitted on this, all this.
Yes.
Anticipating these arguments, we have admitted your appeal, you are on stay.
Yes.
Why an absolute stay should be granted? Because you are Hyderabad Municipal Authority and you are not running away.
There is a region, 3 regions. One region, the award is in the teeth of express provision that is in the concession agreement 6.2F, which categorically says, it is Miller's extracted in the award also, which categorically says, unless COD is achieved, completion of the project is achieved, no annuity prior to that date will be granted at all. And it is a non-obstante clause. It says, notwithstanding anything contained in 6.2, they will not be entitled to any annuity for the period prior to COD. In the teeth of this express provision, which was to be given plain meaning, it is a plain English. Still Miller's honorable arbitrator has awarded 3.5 annuity, and one annuity is 39.40 crores, so approximately 40 crores. So 135 crores approximately has been granted in the teeth of this 6.2F Miller's. I'll show the 6.2F for Miller's kind consideration. 6.2F Miller's will find at page 21 of the Miller's documents which we had filed on 2nd of March 23, I'm sorry. This is in express, this is in the teeth of this express provision. That is my first submission. Second submission is that Miller's.
1 minute, we are.
I'm sorry.
You said 6.25, we have to find out what is.
I
Additional doc. Which page?
Miller's page 20, it starts at page 20, the clause 6.2, and goes on till Miller's page 21.
Page 20.
20 Miller's.
6.1.
6.2, I'm sorry Miller's, it is should be 6.2, if Miller's have got that.
Yes.
This is Miller's bonus.
Reduction in annuity.
Yes, reduction in annuity. Now, kindly come to the next page and kindly see Miller's F, EEF, Miller's.
Next page means 22.
Page 21. Miller's got that.
Yes.
F.
Notwithstanding.
Notwithstanding anything inconsistent contained here anywhere in this agreement. Who does Miller's, my predecessor in interest, who does? Obligation to pay annuity shall arise subject to and only upon occurrence of COD. And the annuity which has been granted by the Honorable Tribunal is for the period prior to that. For the period post COD, we have no problems. It is being paid, Miller's. That's not a controversy at all. This is Miller's plain English. Miller's, no interpretation is needed, but Tribunal has gone into Miller's all kinds of so-called interpretations and granted this. We have no problems with payment of annuities post COD. That is my first submission, Miller's. Second submission for Miller's kind consideration is that entire amount has been paid to the Millards, the other side, the respondent, 3.5 annuity for the period pre-Millards, the COD, and bonus, another bonus of 39.40 crore.
The entire amount, which amount?
Claimed amount.
Award.
Amount claimed in the
Has
arbitration.
your,
No, arbitrary.
he's saying entire amount has been placed in favor of the respondent.
Entire amount claimed by the Millards respondent in the arbitration were under two heads. One head was 3.5 annuity of 39.50 crore for the period prior to COD. And second head of claim was bonus of 39.50 crore. Both have been awarded. Now, so far as bonus is concerned, Millards, bonus payment can only happen if project is completed prior to the scheduled completion date. Scheduled completion date was 29th of June 2010. That is why, my lords, 6.2, the clause which I read over and showed to Millards, whether it is bonus or reduction in annuity. This is the clause. Now, for bonus, Millard know much more than me. Bonus can only be paid if project is completed, Millard, before the scheduled completion date. Scheduled completion date is 19th of June 2010.
No, this is all on merits. You come to say why stay should be granted.
Only 2-3 points, and thereafter, Millards, I'll stop myself. Actual completion has happened on 30th of March 2012. So therefore, admittedly, this is not a case of completion prior to scheduled completion date. Still, they have been granted this 39.50 crore of bonus as well. And Millards, for the simple reason that the independent engineer who was appointed under the contractual stipulation, whose decision was amenable to challenge in arbitration, which we challenged, I had said that IE's reports were fraudulent. 100 occasions we have said so in my SOT. Now my respectful submission, and this is where my point of argument is, that Millards, the IE's report were contradictory. I'll read Millard's 5-6 IE's report, subject to Millard's pleasure. I consistently said delays were attributable to them. However, one fine morning he gets up and he says, you were given ROWs, enough ROWs right of way. You were not able to work on the existing ROW. One fine morning, he takes a somersault and says, no, all delays attributable to me. So, my lords, this delay of approximately 650 days of delay, I has, in one of the letters says, all delays attributable to me, whereas I himself was saying repeatedly that delays are all attributable to you. So in a contract where there are 650 days of delay going by the award and the IE report, not a single delay is found to be attributable to them. When
What is the IE report?
IE is, my lords, under the contract, one engineer was to be appointed.
No, what is IE?
Independent engineer.
So we are not parties to the contract, therefore we don't know.
I know.
So it's your duty to tell us what is.
It is mine.
Why, like we thought IE report means Independence Day report or whatever.
No,
I thought better to ask.
No, I must apologize for that. I must apologize for that. I must apologize.
What engineers?
Independent engineer. Millard, this is basically, Millards, nothing but Millards, the legacy of edict forms of contract, where Millard, somebody is asked to supervise the execution of the work, and he determines how much delay has been caused by which party. However, this is a case, under the contract itself, it is written that I's report can be challenged in arbitration. It's not a case where I's report is final and binding, unlike few cases, Millards, we come across. No. So here it is amenable to challenge. When Millards will, it will take the conscience of this court, with Millard will see repeatedly Millards. In fact, I have prepared Millards one compilation. If Millard will allow me to just hand over the.
You are arguing on stay, we believe. This is not final hearing. This is not final hearing, Mr.
I know. For a stay, I must satisfy the conscience of this court how public exchequer has been put at risk, Millards, in a manner, fraudulent manner, where TIE, may I just pass it? And thereafter, Millards, my third draft would be, Millards, the claims are time barred. Negotiation cannot save the claims. Time barred claims. They say no, there is negotiation going on. So, Millards, I will be relying upon BSNL versus Nortel judgment of Honorable Supreme Court 2021, which says under Limitation Act, there is no problem.
We are not holding right now that awards are, the claims are within limitation or barred by limitation. We are deciding the question of stay, Mr.
Yes. So just to
there is an award in his favor. There is an award in his favor that has been upheld by a court. Your petition under 34 has been dismissed.
Yes, I bought. But Millards, in order to satisfy Millards,
what should we? You should tell us, being an officer of the court, that what should be the court's endeavor at the stage of dealing an application for grant of stay. What should be? You know it with your experience. That give.
My submission is,
you can't record a finding that it is barred by limitation, therefore stayed. You can't do it.
What I thought was this, subject to Millard's pleasure, again, subject to Millard's, entirely Millard's pleasure, that if I am able to satisfy the conscience of this honorable court, that this case is a result of a fraud played by the independent engineer, his own report, repeated reports, saying that they are in delay, and end of the day, Millard's, one fine morning, he gets up, he says, no, all delays on my head. Initially, he says, all delays on their head. And that has been picked up in the by the arbitral tribunal, and this award has gone against me. It's a public exchequer, Millards. That's my respectful submission. On the limitation also, Millards, I'll satisfy that the claims are of 2012. Their claim is of 2012.
No. You should give us principles with regard to grant of stay in such a case. Supreme Court has dealt with it, and you know what is this is a money claim.
Money claim, Millards. My only respectful submission is this. Considering the fact, Millards, that I believe, Millards, I have a good case to make submissions on. Second,
that's why we have admitted your appeal.
I bought. And second point for Millard's kind consideration, I am a governmental body. I am not going to run away. Millards, and third, during entire section 34 until now.
So then don't insist for a stay, right? You are a governmental body, immune for everything, immune from everything. So you manage. Why should you invite order on stay?
No.
You can manage without stay also. File an application for urgent hearing. We will fix a date. We will decide when to be heard. This appeal to be heard. When you come to seeking protection to the court, then we are bound by certain principles.
Millards, in that case, may I request one thing? Millards, next date before the executing court is 31st of October. Will Millards kindly be kind enough to accommodate me on 31st, so that morning I argue with Millards here, and then Millards we go to the execution.
This is one thing. Please appreciate. This is 2023 appeal.
Yes.
And merely because you are a government body, we will not start hearing it at 10:30. There are other litigants also.
I know.
2005 they are waiting. 2006, 2005 matters. Recently we have decided 97, 98 writ petitions, remand from Supreme Court in the year 2006. Our conscience does not permit, because you are a privileged person coming from outside So therefore at 10:30, everybody should be able to, this thing, everybody is looking at you because on a stay you are arguing. So everybody is looking at you. Please conclude, we will decide stay.
No, what I say is.
So you are a government body not at flight risk.
Not at a flight risk. Yes, this is what I say. Not at a flight risk. I'm here. 10 minutes. That, there is one judgment of Honorable Supreme Court, Nihora. I'm sorry, I have not brought that news. That was a case where the Honorable Supreme Court had said that since it is a government body, it was in that context of appeal only. So let them not be burdened with the. May I say this?
No, what government body, therefore stay should not be, stay should be granted.
No, in that case, what was said was.
No, we are trying to know for the principles of grant of stay. Like
while granting the stay, Milords are also saying that, okay, you give some security. You give security. That's another way of Milords handling the Milords application for a stay. This is another way of doing it. In that case, what was held was Milords, I take out the judgment. I'm sorry, Milords, I have not brought it. I must apologize for that. New Sihora judgment of Sihora Nagar Palika judgment of Supreme Court. That in that case, Honorable Supreme Court said, so far as security issue is concerned, since it is a governmental body, it was a Nagar Palika, like in my case. So they should not be there should not be a press. It should not be pressed that they must give the security. My submission is this: this money around 350 crores or more than that, Milords, we are using it for public purpose. Now, Milords may allow me 31st, Milords, any time of the day, 31st, Milords.
No, we can't hear like this.
Because, Milords, my difficulty is this, 31st is the execution.
So that's why we are hearing you on stay. Please go ahead. 10 minutes have passed. Huh?
That
Please
is,
go ahead.
may I, Milords, on some points, some eyes report. Milords may kindly see some of the orders, Milords, some of the letters of IE. First, Milords, there is a compilation I have given. Same compilation.
Resolution in
And in this
the like
compilation,
this thing provided in
See,
the
on
agreement.
merits,
You need not labor because we are admitting your appeal.
The similar
Until this we are convinced that you have, this is valuable grounds, you may not have admitted. This is on question of stay. Repeatedly again, third time we are telling you. Leave a petition, condonation of delay and all that. What can we do with this? We cannot record a finding that it is sacrosanct. Allowing the appeal. All right, yes.
Allow me, Milords,
No.
either 30th or
Hold on,
31st.
not like this. This is not the manner. The appeal has been admitted. File an application for urgent hearing. It will be considered.
Milords, here we had filed that application. This is how, Milords, this date was given by Milords. I had filed an application for early hearing.
So we will fix a date then. You are arguing on stay. We are hearing.
No, difficulty.
Choice is yours. Whatever.
Difficulty is this. If Milord will be able to hear it in one go, Milords, everything comes to.
That applies to every case. Why this case? Every case. Why 2005 appeal should not be heard at one go and judgment should not be pronounced immediately. Tell me as such any reason. Writ petition lies.
I filed a judgment.
We would like to see.
Yes.
Where is
This
it?
is Milord Sihor Nagar Palika judgment.
So all like
2005, volume 4,
no
STC,
suit is
page
required
1.
to be filed. Everything, all government companies, state government, writ petition, 2004. Interesting. We will like to see given us a copy.
Milords, I should have. Milords, I must apologize for that.
Lords may come to
This is 2005, volume 4.
the dates, Milord, two days. The lease has been entered, it's not been disputed. 15 years lease is over. Subsequently, they did not invoke Milord. But second entry, Milord, 18/6/2003, lease was entered. For 15 years, lease has come to an end. The Lordship done overleap. The rest of this, the Lordship can skip, Milord. Second is lease is entered. Second overleap, Milord. Milord, third, 1/6/2021.
Page 1, 2005, volume 4,
1/6/2021, we
page
issued a
1.
letter saying that please vacate the
Paragraph A.
Grant of stay.
14/7/2021.
This is my lords SCC,
First time they
Sihor
addressed the
Nagar
letter to
Palika
for renewal.
Bill.
Overtake.
This is my lords order
which is
41.
the judgment?
Yes. I've
That a writ
And
petition
my lords may kindly
can
come
be
to
filed seeking relief of
para
possession.
8.
Yes.
Is it not a
That's a
contractual dispute, Mister? What
Yes.
is the
Contractual
facts and
dispute
circumstances
Yes.
and what is the mode of
In the
one minute?
facts and
What is the mode
circumstances
of
of the present
resolution
case and have
in
been taken
the
into
this
consideration the
thing
respective
provided in the
submissions
agreement
made
in
by the
case of
learned counsel
dispute?
for
What
the
is the mode
parties
of
in the
resolution of
remaining
dispute?
claims.
No
We are
arbitration clause.
satisfied to hold that High
No
Court ought to
arbitration.
have permitted furnishing of
What does it?
security
Let's see.
instead of
Where is the
insisting on
agreement?
depository
And
It is
stamp
at page number
amount
46, madam.
as directed by the
46.
High Court. It is not the case of the respondent that in the event of appeal being dismissed, the digital amount may not be recovered from the appellant. On the other hand, the appellant has made out a prima facie strong case for hearing of the appeal on its merits and further a case that public interest would be better served by the amount being retained by the appellant during pendency of the
12 of the
appeal.
relevant
While
part,
making
that
this
page number
observation,
is
we
up.
should not be understood as having made any observation touching the merit of the case amounting to prejudging any of the issues arising for decision in the appeal
Back
and
to it. Clause number 12 at page number
independente
57.
cautelia. We clarify that appeal shall be heard by the High Court on its own merit, uninfluenced by
They had
any.
to renew it before
Appellant
the
has
expiry of
already
the
furnished
lease.
security of immovable property to the satisfaction of the trial court pursuant to the order dated so and so price. So, my lords,
So,
if
per se,
Milords,
there is no
I cannot
dispute
be
relation,
heard,
therefore,
Milords, on
the provisions of
31st. In that
Transfer
case,
Property
Milords
Act may apply.
Cannot be heard means we are not saying you can't. There is a practice,
Clause
right?
12.
Because you are appearing, so today
Clause
it should
12
be
at page
heard,
number
judgment should be
57,
delivered to your Delhi office. Is this the practice?
No.
What is this? Can't be heard and all this?
No.
We said you have to make an application. If the
There is no
application is
dispute
there,
over
we will
whatsoever.
consider it.
Milords, there was an application.
There was an app.
No, we filed an application and this is how Milords were able to. This matter
And where is the judgment
so
of
it is
Supreme
orders
Court
from
saying that
IA4.
Yes.
Suit or possession can be
So that
filed
you
under
did not say,
Article
you are
226.
saying that you are arguing on a stay. We are hearing.
First is page number
So
69.
my respectful
madam.
submission,
69.
Milords, I understand.
And there is a
Milords.
delay to be
I
confirmed.
it's a practice, Milords, and Milords.
That is in
Not
our
only case of
discussion when we
say,
fix the
mighty oil
date, not
corporation,
the way you want.
No,
That you want on 31st, you want on a Sunday,
Sorry
because
to
it's
interrupt,
convenient.
Lords,
No,
that
no,
therefore
judgment
we
is
should
referred to by
region,
the
Milords, I
apex.
said for a reason that
learned single
31st
judge in
executing
her
court is listening this. Otherwise,
You argue on a stay, whatever you, we have admitted your appeal for hearing.
on Milords,
This is, Mr. One thing we must tell you, it is
He is
listed for
appearing in
orders
your
on
case.
admission.
For the respondent.
And this is item 19, orders for, it is
We were
listed
also
for
not
orders
aware.
on admission and
yes.
CA.
Yes.
That is state
respondent,
petition.
sorry.
There is no application for early hearing
10, if
listed
your
today.
lordship sees the learned
If you
single
have
judge
this is
not
judgment
filed
on
it,
page
better
number
filed it,
69.
it will be
Let
considered
it
on
complete,
its own
Mr.
merit, we
If
will
you want
consider.
to. You have
While
filed
the
a case
caveat, we will
like
hear
this
you
also.
for admission and IA only.
Yes.
We have admitted, we are hearing you on a stay.
yes. So my respectful submission, Milords, in view of paragraph 8 of Sihor Nagar Palika, Milords may direct us to give the security, Milords. We can give the security, Milords, and Milords may kindly hear us. I can't give you that.
Anything else?
Nothing.
Only
Yes.
1 minute, my lord. The entire ground on which they are seeking stay is page 40 of the affidavit, para 22, my lord, saying that the government body. Page 40 of the affidavit, IA1.
IA?
One, that's the only ground they're asking stay. Page 40, para number 22.
Which appeal paper book? This rate,
IA, interlocutory application.
IA,
IA1, my lord.
one of, where is one?
There is a stay application, my lord.
1 minute.
It's an appeal paper book, last page, my lord. The appeal paper book, last page.
Last page.
Last page. Page 40, my lord, para 22.
IA. This is it. IA. No. Oh, 1 of 20. You put a flag here.
Milords, in
When
fact,
it is
appeal
listed,
runs
full-
into.
Page 40, my lord. Para
1 minute we have.
I was assisting with the page number.
We have got it. Yes.
page 40, para 22, my lord, the only ground. Para 22 is only merits, my lord. It is respectfully submitted. Appellant petition is a government body and substantive public is involved in the present matter and prejudicial and the illegal award dated so and so is not state by the honorable court. That's the only ground which we have raised. But it is directly covered by the Supreme Court's order, my lord, in PAM developers. AR 2009. But my friend was really sure, even that was also considered in para 19 by full bench of Calcutta High Court, and that was approved by Supreme Court.
Para?
Para 19, my lord, full bench of Calcutta High Court. Your lordship would notice that full bench of, they referred to Seor Nagar Palika, which my friend just now read. And my lord, para 37 of the Calcutta High Court, they say to hold that court is denuded of such equitable.
This is Supreme Court or Calcutta High Court?
No, I'm saying Seor Palika was referred in Calcutta pen. Last sentence, we find no reason to disagree with such view taken to the full court. And the ratio rate is in para number 26 of the judgment. PAM developers. 24.
So what is it? Para 90?
Para 19, they refer
Full
to
bench of Calcutta High
Calcutta
Court.
High Court, and that was approved by the Honorable Supreme Court in PAM developers. We find no reason to disagree. Last sentence.
So what is the view taken?
View taken is para 37 to hold that the court is denuded of such equitable discretion while granting stay of execution of money decree in favor of government would cause grave hardship to deserving decree holders who in fact of a given case may be entitled to enjoy part satisfaction of decree without prejudice and subject to the result of the appeal as a condition of stay of the intent. So that conditional order was approved by the Honorable Supreme Court, my lord.
What was the conditional order passed?
But any condition being imposed, my lord, that's what they said. Just because they are a government or public body, my lord, doesn't mean that they create a blanket stay. Because so Honorable Supreme Court interpreting 27 rule 8A, my lord. My lord, then para 25 of the same jet, PAM developers.
Yes.
It may be true that code of CPC provides for a different treatment government in certain cases, but the same may not be applicable while considering cases of government under Arbitration Act. For instance, section then you have para 26, my lord. Section 36 of the Arbitration Act also does not provide for any special treatment to the government while dealing with grant of stay in application of proceedings of section 34 of the Arbitration Act. Keeping the aforesaid constitution also the provision of section 18 providing for equal treatment of parties, it would, in our view, make it clear that there is no exceptional treatment to be given to government while considering the application for stay under section 36 filed by the government in proceedings under section 34 of the Arbitration Act. Then, my lord, they direct 100% deposit. That means this view has been followed by Supreme Court in Toyo Engineering, my lord. %100% stay deposit, my lord. There's one more judgment of one Supreme Court falling safe if the government doesn't have a separate treatment. Both these considerations are irrelevant. My lord, your lordships had an occasion to deal with 30. This is under 37. My lord. They lost arbitral award as well as 34. The lordships had an occasion to deal with this unless the scope cannot be.
That scope of appeal is akin to 34.
Yes. In the case of RB Singh versus Vindhyachal superpower, my lord. my lord, your lordship, at para 6, consider the entire jurisprudence prevailing as on that date, my lord. Then para 7, your lordship have laid down ratio, the background of the aforesaid 12.
There is a division bench judgment, like.
But last is, my lord, this court does not say, division bench speaking of this court, my lord. They also to give you that 100% has to be deposited and 50% was to be withdrawn. A division bench of this court, my lord. In CRP number 2967 of 22, commercial matters, my lord. Para 34, my lord. As there are serious different respect of facts, payments of arrears, rents in case, the commercial court of recording tribal content put forth by parties and conditionally. However, commercial court already not granted leave of withdrawal of money per evidence. Having regard to facts of the case and to balance the equities of both the parties, we are inclined to modify the impugned order. We directly respond to deposit 100% of the awarded amount by the learned arbitrator, wherein 50% of the pay and remaining 50% by a bank guarantee in the form of pledging immoral assets equivalent to 50% so or the contract. On such deposit, we allow the payment to withdraw 50%.
Who were the parties to this?
Private parties, corporation.
What is the amount due to you under the award?
Well, 180 crores is the due amount.
180.
180 crores. Principal amount.
Ah.
No, it is not as though they are giving me charity. I invested money. I constructed 11.7 kilometers of ORR road. Now this annuity has to come as a recouping of my investment. It's not that they are giving me user fee charge.
So what is the amount due to you under
As on today, it's about 360 crores.
360
crores. From 180 crores is my principal amount, my lord, as on that date. That's up. In case they have to be granted the state, then there should be payment on the part of the entire amount, as per the law.
Millets, only one respectful submission, Millets. The two judgments cited by Millets, my learned colleague, are of Millets coordinate bench, division bench of Supreme Court. So far as Millets, this judgment which I cited, Millets Justice Lahoti judgment 2005 judgment, that is also Millets two judges bench judgment. Millets, if we have Millets two judges bench judgment, laying a law and subsequently another coordinate bench cannot Millets in conflict with that. If that happens, Millets, the precedent would be if it is two judges bench judgment, Millets, in conflict with each other. In my respectful submission, prior judgment is the precedent because coordinate bench cannot go in teeth of what prior judgment says. Millets. That's my respectful submission.
They have not overruled Sihor, whatever municipality,
Yes.
2000, this thing, they have not overruled. Because all right, you are entitled to present, but we hope that you understand what is the ratio in Sihor municipality. Para 8, you please read
Para
it again.
8 Sihor says.
Again read.
Yes.
Again read.
Para 8.
We are a senior counsel, you understand, right? But you are under an obligation to argue in this manner. So please see what is Sihor municipality. Para 8.
Yes, may I read?
And where it has been overruled by subsequent
I'm
decisions.
saying, Millets, if Sihor, if Millets, the subsequent judgment,
It has not been overruled, Mr.
if subsequent judgment, Millets, for whatever reason, does not agree with the previous judgment of coordinate bench, in that case, Millets, previous judgment would be the precedent, Millets. That is my respectful submission.
So the submission is that 2005 is the binding precedent on this court, right?
This is the precedent.
Ah.
Note, Millets, the subsequent judgment which disagrees with that judgment. And Millets, I send some judgments, I give some judgment on that, Millets. That previous judgment is the precedent. That's it, nothing else. This is a very preliminary, I know, Millets, but that is my respectful submission, Millets.
No, be satisfied. If you want to give judgment on that also, please give.
Now, question is, Millets, the judgment which my learned colleague has cited, this honorable court judgment, I do not see the, the name of parties in that judgment.
He has said private parties. That's why we asked him.
And secondly, Miller,
Some corporation,
Huh?
private parties, correct? In
Ah.
respect to
Where is the 2005 judgment? For where is the book, madam? I am looking. Huh?
farm development is, Miller, two judges bench judgment. And another judgment, Miller, again,
See.
Soyo engineering is two judges bench judgment. And so far as, Miller, this division bench judgment is concerned, Miller, this is here, Miller's, as had been said, Miller, it is 50% and that too it is a private party. That's it, it's nothing. Millers, we are ready to give security, Millers. We are in Millers sense.
No, why security? This CPC this thing exempts you from providing security.
Pardon?
All right, we'll record your concession that you are ready to give security.
Millers, if we have to give security, we are ready to give security, Millers, against the Millers, the money deposit. We are a public sector, kindly consider. That's it.
Ah. Yes.
Millers, my instruction is, Millers, my consent may not be recorded for the security, Millers.
No, nothing. You want it to be the order to be set aside, that we will record at this stage. So,
Stay, Millers. I'm saying stay, not Millers setting aside. I'm saying stay.
you are so clear about focus. There's no question of granting your concession. We understand. This order is subject to SLP. We understand that. Yes. This appeal, mark the presence. only for IA.
I know.
Right there, it is good. It is made clear that the observations have been made in the order only for the purposes of deciding IA number 1 of 2023 and have no bearing on the merits of the case.
Dip.
One ground in SLP. So that we wanted to clarify. Yes. Yes. Next. No, lighter vein, Mr. Case. No, Mr. Senior Counsel, case is over in the lighter vein we are saying something.
I'm saying
you should appreciate that. There is nothing. It's a constitutional right. We cannot take it away. Merely, we can be take away by merely saying this is a constitutional right under Article 136. We know that. So we are just lighter vein. Too much of seriousness. I cannot all the time, Mr. But you are all occupied and so serious that you even forget to smile.
No.
The order has been passed. We have done our job. It will not be altered in any way. Happy today.
One respectful
Happy today. Yes.
One respectful submission, Millards have given 6 weeks. Millards may kindly extend slightly more.
No. That is done. 6 weeks we have said.
Millards, if Millards can consider Millards 10 weeks at.
After the order was dictated, learned senior counsel for the this is then, Mr. Then this thing we want permit this, right? You will say that I had extended this thing after the order was dictated. Learned senior counsel for the appellant said that time for depositing the amount be extended by.
I'm not saying Millards.
Extended by.
Except I'm not saying that I'm accepting the order and therefore Millards. I'm saying,
No.
Delete.
Not delete. Delete. Certified copy. Yes.
Obliged.
Huh?
That's a state is in appeal.
Counter affidavit to additional. See how this is.
That's in condonation application or delay application. I was.
So how much time? 1. You can have 2 weeks. 1 week the court will be closed now. So you pray for 2 weeks now. 1 week automatically by default you get. You can smile. Why are you so serious? One additional week by way of bonus you are getting, so you can smile for that, right? Learned counsel for the respondent. Your respondent. 2 weeks time to enable. To move an application for early hearing in this case, we would like to do it, but presently we are battling with arrears. Like there are 29 cases, 2005 to we have found out. That's why we are telling you the figures. 29 cases up to the year 2010. So we want to finish it off in a mission mode. So therefore, this is pending since 2022. We'll hear it, admit it. Please file application sometime in January, February. We'll consider.
Very good.
Mark the presence. In this batch of writ petitions, the petitioners have assailed the validity of Rule 4, 7, 12 and 13 of Telangana Minor Mineral Concession Rules 1966, which has been notified by GO dated 31/3/2022 on the ground that the same is illegal and ultra vires and contrary to section 14 and 15 of the Mines and Minerals within bracket Development and Regulation Act 1957. Full stop. The petitions are admitted for hearing. The pleadings in the case are complete. We just move sometime. We will hear interesting point. We would like to decide.
Do we raised several grounds, my lord, in view of the recent Supreme Court judgment, almost except one ground, my lord, other grounds they not survive.
All right. So you give that Supreme Court also. In support of his submission, learned counsel for the petitioner has placed reliance on decision of Supreme Court in has made a reference. Has made a
Against us.
Huh?
It's in fact.
all right,
against
all
us.
right, all right.
I just.
Learned counsel for respondent. Delete. Learned counsel for respondent has placed reliance on decision of Supreme Court in
It's possible. Civil appeal number.
not reported.
Not.
Which your judgment?
It's 108 page 1. State of Rajasthan versus.
Has placed reliance on the state of Rajasthan and others versus Shravan Kumar, Kumawat, etc. Dated. So what ground survives 1st of August 23 in civil appeal number 1162-1171 of 2016? What is the ground which survives in view of this judgment?
I raised grounds that the government has no power at all to conduct auction of leasehold rights. Supreme Court said simply because the citizen has filed an application for grant of lease does not give any vested right to prevent the government from making an amendment. The other ground are now I am pressing is that the government has declared the pending applications as ineligible.
That is the point. That's the point. We will hear it. Yes, please file in some January. It's 44. Not showing. 40.
May please, Lord.
You are the petitioner.
I am the petitioner.
Right. Yes, nobody is opposing you. A good sign, good omen. Nobody is opposing you. So they have to this thing make payment.
That's
58.
With respect, Lord, it's a bad omen for me because once the other side is not there.
No. We will, if they are not appearing, you good omen in the sense, there is nobody to oppose you and you are entitled to interim relief. Right?
Oblige.
So what is it? You have filed an application seeking
No, as a matter of fact,
pension.
Pension, Lord, pensionary benefit.
Under section 58.
Yes.
Are you entitled?
Under 59, section
59. Give state reorganization act.
Before your
section
yes.
50. Now he has appeared according to you. So now good omen eventually according to you.
Either way, Lord, appearing before Lordships itself is a good omen.
So, section, yes, what do you say?
Second response, file counter in Lordship, please.
Huh?
Para 9, we are accepting Lordship. After 59, your Lordship, there is a.
No, the prayer is for pension, right? He has to be.
Here
He has to be paid pension, right?
The tribunal was.
In the ratio of this thing, 58 to 42%, correct? 58% Andhra Pradesh, 42 Telangana.
That's why I made.
He is entitled to pension, Mr. How will he survive?
Just
This
stated
man?
in para 9.
Yeah,
We are ready, Lord. We have stated
Ready?
para 9 of our operating Lord.
what ready?
Telangana government filed counter offer for whom my friend is appearing, stating that we are willing to pay.
All right. Oh, so
In so far
provision
as AP,
pension you will pay.
48%.
All right, 42%, not 48.
Sorry.
58 and 42, right?
58 Lord is opposite.
Andhra Pradesh.
Andhra Pradesh.
Yes, mark the presence. Heard on IA number. Yes.
May I please the Lord? This is coming up for Lordship's consideration for IA2 and IA3. IA2, where I have filed writ petition challenging one amendment was made to Act 2 of 94 by way of executive instructions.
No, but this IA one is what implead.
To IA2 implead the party, the persons who got given the benefit of the Act 2 of 94.
And so we will issue notice to IA.
Lordships have already 16/8/2023 Lordships have issued notice.
Who appears? They have been served.
They have been served. Registry has verified.
Yes, madam. Notice on IA 2 of 23 has been served. Asks.
Learned Advocate General will appear in this matter. Your Lordship's counter is going to be filed, Your Lordship's.
That's also acceptable. Lordship.
Counter is awaited, right?
On 16 IA3 Lordship may kindly peruse the docket for a moment. Undertaken was given by the
Yes,
AG.
we understand, Miss, that this thing you are challenging the rule insofar as it seeks to regularize illegal appointment. We know that.
That is main prayer. But subsequently, when the matters came up on 20th.
They want to file counter, right? Everything is subject to this petition now. You are before this.
Again, my humble submission. Lordship, allow me to make one submission.
Please, not only 110.
I'm sorry.
Why one?
I'm obliged. 24/2023, the matters came up for consideration before this honorable court. This honorable court was pleased to order notice. Once notice ordered, Millard, they ought not to have proceed with the matter. On 28/4/2023 is the last working day of this honorable court. On 30th, 28/4/2023 is the last working day for intervening of summer vacation. On 30th, very second day, they have issued GO 16, granting permission to the appointing authority to regularize 5,544 individuals. Once the matter is sub judice before this honorable court, they cannot proceed. The similar issue like judicial officer appointments were fell for consideration before the honorable apex court.
Notices were ordered on 18/4, matter directed to be listed on 28/4. Meanwhile, promotions were effected by the Gujarat government, and the Honorable Apex Court seriously taken a view that it is nothing but overreaching the process of the court and to defeat the object before the court. I have appended those orders, my lord, and the subsequent events are brought to the Lordship's kind notice. GO may not, the amendment may not be suspended, but subsequent events, when the matter is pending before the Honorable Court for sub judice, that has to be suspended. Otherwise, again, they are calling for the particulars of 1,000 and odd people. That cannot be.
No, but code of conduct now. Code of conduct.
Even then, they asked, if Lordship so pleases, my lord, on 30th night,
Where
they
is
asked
the IA? Have you filed some IA?
IA 3.
3. Where is that?
IA 3, my lord, I have filed in the month of August, 9 August 2023.
Put a flag on the IAs, right? 3. They are not filing, what to do? Madam, this don't do anything then. If you are seeking time, then don't do anything. Don't regularize. We cannot grant you time and this thing. Arey, Mr. Prasad,
Before your lordship.
Prasad,
Speech.
this matter pertains to this thing. Council is arguing, she is not saying anything. We want to tell you, and there is a point. Let's see, validity of Rule 10A of the rules has been challenged insofar as it seeks to regularize the illegal appointments. His submission is that after filing of the writ petition, when notices were issued on the last working day before summer vacation, you issued an order of by which services of 5,000 employees were regularized. Now you have initiated the process here. On one hand, you are seeking time to file counter, right? She is again filing time to file counter and saying Advocate General will appear. That's correct. But his prayer is that till such time, you should not further this thing regularize the services. He has filed IA 3 of 23. Please see which is this thing.
GO 16, my lord, then Lordship may kindly come to
Suspend the operation of April, May, what is?
They are seeking regularization of the employees of 5,500.
No, these are what orders? 1/5, this thing, it is past 5 months ago.
Yes. Kindly see page 24, my lord. The order of this Honorable Court, Lordship may kindly come to.
No. Arey, what you are seeking of stay off, mister? That's what we want to.
I have confined myself. They cannot proceed further. Now onwards, they cannot proceed further affecting the impugned orders.
No, you are seeking stay of entire GOs?
Yes, and subsequent GOs. I have challenged the section, but once the case came up before this Honorable Court on 20th, they cannot proceed further until unless it is decided by this Honorable Court. Once taking the vacation as a advantage, they are proceeding left and right, 5,500.
Left and right means what they have done, mister. We want to, you are not telling us left, right, center, going.
Sorry, page 24.
You go northeast, northwest also, north. So left, center.
Page 24 is the crux of this issue.
Page 70, one such order is 1/5/23. Of which we are seeking a stay. It was issued, we want to know, it was issued 5 months ago.
Yes.
Now what is it they are trying to do?
They are trying to, by virtue of these 38 GO, now they are presperating the things, sought for the candidatures of the individuals, 1,000 and people odd to regularize the services. Meanwhile, election code has been come.
So then they can't do it.
Yes.
Code of conduct, they can't do it now. They, at least you can, we will record your statement, mister.
Yeah.
That in view of code of conduct, you will not take any further action.
Yeah, they are report to me about 2:30.
All right, 2:30.
I just go through the thing.
Yes, please. No, but it's such important matter. She doesn't know anything about the case, whether she should be interested with the file. She has come only to ask for counter and telling us AG will appear. But we have to, he is insisting for an interim order. Yes.
I'm deeply offended.
I'm appearing for petition of law. The matter is coming for consideration of IA number 2.
Yes. Yes.
IA number 2 is coming for filed for restrain the respondent 3 and 4 not to recover the amount from the petitioners.
What is the complaint?
Complaint, the writ petition was filed challenging the action of the respondents, issuing the notice to recover the amount paid for compensation, granted compensation for a land acquisition loan. As one of the
921 directing loans. So it is. Yes, what?
My lord, I am for the respondent number 6, my lord. I am the landowner. My name was.
No, that's correct. But what type of, how does Lokayuk direct
No,
the?
Lokayukta not directed, my lord. Lokayukta said officers were wrongly paid the amount to.
What is the order dated 6/9/21?
Yes, my lord. Can you see, my lord? Wrongly amount were paid to the petitioners, my lord. That was the conduct inquiry and they want to recover the money, my lord. Because I am the landowner, one of the land, my lord. But
No, but how can Lokayuk do it? That's the which provision?
because of the officer's fault. Yes. Officers can fault, my lord, the Lokayukta.
Just
Page number 19, my lord.
Page?
19.
19. Yes. Translated version you have filed?
Notice, my lord.
Notice.
Page number 18, my lord. 18 is the order. Sorry, my lord. Page number 18. The basing on the report submitted by the officer.
Just a minute. So which provision he can direct like this that you recover the amount and deposit it with me? Which provision of Lokayuk Act? Please tell us.
Just now, filed the wakalat recently, my lord.
No, there's no provision, you know it, Mr. Lokayuk Act.
The thing is that we have protect illegality by mentioning the wrong statement during the statement before the officers. They have taken
To take action, Mr. There are remedies available to you in law.
remedies are
Take
there.
action.
Yes,
It's not the approaching Lokayuk. This order, how can we sustain it?
instead of filing repetition, they have misguided to go for the Lokayuk.
Correct. Now you correctly advise them, don't go to Lokayuk, come to me.
Come to this.
Huh? You call them in your office and advise them properly. But this order can't be upheld, right?
But liberty
Now
will be
they-
given, my lord, to.
Yes, of course. This is item 47, no? This order on IA 1 of 23, this requirement is dispensed with. Then with consent of the parties.
I'm for the first and third respondents. May kindly grant 2 weeks for filing counter.
The petition, you've taken title for last edition for filing a counter.
Not filing, madam, why?
2 and 4 have filed, my lord. Andhra Pradesh has filed the counter.
Ah, learn it. 2 weeks time is 3 weeks time is granted by way of indulgence to enable the so and so learned counsel to file counter. Yes.
Please, my lord. I appear on behalf of the writ petitioner, my lord.
Ah. What it is to fix a date of early date.
True, my lord. This honorable court was pleased to pass an order on 20.
No, but we are wondering what time is it there, Mister? You are awake. Huh?
12:38, my lord.
12:38. He is awake. Yes.
My lord, your lordship was pleased to pass an order on 21st July 2023 saying that the respondent has agreed not to announce the results. Then the matter was posted for counter. After the counter is filed, my lord, even before the matter could be taken up, now they have declared the result on 5/10/2023 and they are proceeding with the selection, thereby defeating the entire purpose for which we have filed the writ petition. The learned judge division bench recorded on 21/7/2023 that prima facie GO 46 is not in conformity with the presidential order. Therefore, my lord, the procedure which they have adopted by introducing GO 46 defeats the presidential order with regard to the candidature of the local candidates who are belonging to the local area of the contiguous District 1.
No, so when they have announced the result?
5th October 2023.
How? You have filed some IA?
I filed the IA now for IA 1 is for the stay petition. IA 2 is only a fixing an early date because they filed a counter.
What?
Not to proceed further with the finalization of the selection and the issuing the appointment orders.
Day after tomorrow.
What day after, Mister? You have given this thing an undertaking that, I mean, formal counter would be filed within 2 weeks and till such time result would not be announced. Technically, you are not bound, but the matter is sub judice, right? Do you seek play and hide and play with this seek?
Day after tomorrow.
What day after? What is your answer? How have you done it? Day after tomorrow means what? Ask, brother. Please ask.
Make your submissions. You have already filed counter.
No. We are asking you, how can you proceed with the result? Like this thing, you have given an undertaking that result will not be announced till counter is filed. You have filed the counter and then announce the result. Is it fair on your part? Technically, you may be correct, but is it fair that we rely on you? You behave like this. Why do you want it day after? So where is he? Mr. Prasad, see. No, that's correct, Mr. But seek the conduct. I mean, the council said that we will file counter within 2 weeks. Till then, the result will not be declared. So relying on that, court said that we are not inclined to grant any interim order because he has agreed. Now, technically it may not be contempt. Like you have filed counter only till filing of the counter. We had agreed that result will not be declared. Should you not, like, matter is sub judice, your counsel gives an undertaking. Should you not seek leave of this court in all fairness? Technically, you may not be liable for contempt. Is it like? And he is not saying anything except day after tomorrow. Day after. Mr. Yes, he is paying, is not unwell or something. What we ask, see, Mr. Something is done. If he is not well again, Learned Counsel for respondent prays for adjournment on the ground.
Early number may.
No, it will come. Early number means today has it not reached?
The early number, I mean, the maybe the start of the list will have so that my.
You can make a mention then. After, provided your friend is there, we will take up.
Obliged.
My lord, this is a covered matter, my lord. Relating to trade license fees.
The last occasion I brought
Members of Petitioner Association. List.
The last hearing, my lord, the names of members were sought to know. I have
List
said
of
three
members.
my lord. I have filed those names with along with the memo.
Where? No, see, Mr. This blanket sort of a stay cannot be granted. Anybody will say, I am the member of the Petitioner Association covered under the order, and he will not pay the license.
He has to pay the court fees also, my lord. He has to pay each individual has to pay the court fees also. In order to avoid that, my lord, association is coming forward.
You file objection.
Last
Learned Counsel for the, yes. Where is the list?
Let me submit
It's not, please, please.
What is
No, but
challenged is the GO, my lord.
Memo. Where is the memo? Said
Memo was
resolution.
filed on 11th October, my lord.
We are trying to see that how many people are there? 13. Hotel. What is hotel?
This has become very much necessary because, my lord, to review the business licenses.
No, that's correct. But why they can't file a petition? Are they so poor that unable to pay court fee?
Everyone is the hotel holder, my lord.
Not
Hotel
my
holder.
lord.
Fun.
Kind my submission, my lord, with due respects. What I have challenged is a GO, my lord. If we want all the members to file against the GOs, lakhs of petitions will be filed.
No, not lakhs.
It doesn't serve any purpose.
Lakhs, you only 13.
No,
You have given a list of
this case,
13
my lord,
people.
throughout the state, lakhs of.
No. What we are saying is, we are not saying that this thing you are claiming on behalf of association. That means that is good for us also. That we don't want to entertain lakhs of petition. There is no space to keep the record. Correct? But we want no confusion or uncertainty. Like this thing that. So this is no affidavit, Mister. No affidavit. It's here memo. You have to, Mr.
Interim orders were issued.
No. Amendment, you make an amendment to the petition saying that these are the members, one paragraph. It has to be supported by an affidavit, what like handwritten memo resolution, who has signed, and if supposing these people deny that it is not my signature or anybody, then what is this? Please file. Mister, you could have amended the petition incorporating their names that these are the, it's a registered association, whatever. These are the members, 1, 2, 3, 4. The statement will be supported by an affidavit. That's all.
Corrected,
We are prepared to grant stay. We are not saying. But this is what you are doing. Like you did not disclose the number of members. Then you have, it's a handwritten thing, which is not even readable. Also, item number 10, if you can read what is serial number 10, which is the name, what we don't know. Prank, something. What is prank?
In similar cases, my lord, in case of association, your lordships have given, my lord.
This is a case of association, Mister. If any,
Espar, my lord. 10th is Hotel Espar.
if you don't want to do it, we will pass an order. If you want. That's what we are asking for.
Sure, my lord.
This can't be done like this. In compliance of the order dated 29/9/2023, Learned Council.
May I please?
See, this should all confirm the firm condition. No, whatever law should be followed.
Petitioner was allotted a seat in the third respondent college, Lordship, and she was directed to report by 7:10. However, she could not take
Mr. Rao.
Lordship's-
Yes. Yes.
Well, to that subsequent notification was issued
Ah.
and the seat was filled by the subsequent counseling lordship. Seat is not available. Blood, he was supposed to join on 7:10. He could not join. 12:10, Lord, the another.
So you put a counter and say all this, like we can't.
If any seats are available, Lordships.
Any seat is available in subsequent.
That will be only blood through notification only.
So that he can participate, right, in the subsequent.
Lordship,
Candidate who did not join, Lord, after allotment is. not
What
entitled.
can be done?
Lordships, she could not join, Lordship. She could not, due to, she was suffering with fever and she couldn't mobilize.
What fever?
Lordship, a chance may be given, Lordship, for
The chance what provided Mr. Rao, we can do only in accordance with law. Mr. Rao can do it. I mean, his own means of doing. So if he agrees, we have no objection. But please.
What my submission, Lordships, here is a case, she want to.
Let him file counter then. What can be, if he can't be decided like this? We thought that he's saying that.
Because.
Let him file counter.
Lordship, vacations are intervening, Lordship, the counseling will be concluded. She'll be not having any chance.
We can, you file it by tomorrow, day after we can take up. Mr. Prabhakar Rao, Learned Counsel for Respondent University undertakes to file counter on or before next date of hearing. List on Friday, we will list.
Yesterday, your lordships adjourned this matter for instructions, my lord. This is the case where, my lord, may I explain? My lord, this is the case where due to the inaction on the part of the second respondent in preventing students who had already joined in All India quota and in the neighboring state of Andhra Pradesh, now the result is that 164 seats have been blocked by my lords, which includes nearly 70 clinical, these are cream seats, my lord, in some of them in government medical colleges also.
No, what is your case?
But may I repeat, my lord? The case is that due to the inaction on the part of the second respondent, it curbing, my lord, certain students have already got seat in the second phase in All India quota, my lord, and some of them got seats in Andhra Pradesh also. Those people having got the seat, having joined their colleges, they again came and participated in the mop-up counseling and blocked the seats in this statement.
No, they means who?
Lordship.
Very easy for you to say. And we are looking this lighter way, Mr. You must enjoy the humor.
Very well.
You are saying they. We are looking at your hands and unable to find. We are looking at the cost title. There are only 2 respondents. So where are they?
My lord, they are several, my lord. They are like
Then How, supposing if you would have got admission, just a minute. How can we entertain a petition against those who are not present before us? Tell us. They means who? They means who has been admitted, what has been done. Like this, just entertaining, just like having a thought sitting in the bed that, oh, they have admitted like this and they have done it. What is the basis? Who has done it? What? How did you know that they means, first of all, they means who?
My lord, they are at page number 24.
They are not.
Lord, they are not parties here.
Wait, so then what do you want us to do? What is the result of not?
Yeah, my lord, what I am seeking now, my lord, is that this is a merit-based counseling, my lord.
How can we grant relief to against a person who is not party? This is a roving inquiry. We can't make in a writ petition. No, it is not implemented anybody.
My lord, may I submit, my lord? This is a merit-based counseling, my lord. A candidate who has.
No, go ahead. We will pass orders. We were just thinking of what to do. Like, so if you insist on arguing, we will pass orders.
I'm sorry. I'm sorry.
No. There's no, like we were trying to suggest you that if you want any effective relief, otherwise it's very easy for us to say they are not here. They are not.
I'll wait.
They are
I'll wait.
not here. Therefore, petition is dismissed.
I'll wait.
Wait means you will have to make an application for implement, Mr. Wait means what? How? Please go ahead. Yes. Argue whatever you want.
My lord,
what can be done, Mr. Despite being told you are not understanding. Twice we have told you.
My lord,
The clients have to thank.
difficulty, my lord, is that on 20th, that is in 3 days, the counseling will close, my lord. That is the difficulty. There is no time to implement. 20th, it is closing. My lord, what? That is the reason, my lord, your lordship.
No. So there no time. So therefore, don't implement. The court. No. Supposing if you would have been a person whose admission would have been cancelled without hearing, then what would you would have said? Arey, how this High Court can do this?
Lord,
Without hearing me, my admission is cancelled.
My lord, one sufficient, my lord. One sufficient, my lord. My lord, this is a merit-based counseling, my lord. A candidate who has failed to secure a seat in the first 3 rounds of counseling is now going to get a seat.
No, where is which candidate? That's what we are asking. Which candidate?
The remaining candidates in the state of.
Which candidate? There has to be definite person like. What like you want? Which candidate? What is the basis that who has been given less meritorious have been allowed to appear in which counseling? When it was held? How do you know? Where is like just saying like this?
Once we know, your lordships will find it page number for a minute.
It's strange. Tell us. This he is saying less meritorious people have been. We don't know what is his case. He is not arguing. You tell Mr. We are at this thing, some confusion. What is your case? You first argue your case. Make out a case for admission. Don't be guided by our query. We have not understood. My brother is saying something. I am thinking something else. So you find what is your case?
My lord, on 4th and 5th of
No. What you? Who are you?
My lord, we have already secured seats, my lord, in the previous rounds of counseling. We have filed our.
We means petitioners.
Petitioners, my lord.
Have
Your
secured
lordship will
seat
find
which?
the details at page.
No. Which case? Which course? PG course,
PG course,
undergraduate.
my lord. PG course, my lord.
All this.
Lordship. Lordship.
You have secured PG course in which round of counseling?
My lord, in page 14, I have given the details.
Which round?
Lordship.
You are
in
here
various, my lord, in the first and second round of counseling.
first. So now
My lord, first and second round of counseling.
you have already been admitted.
Already been
Now,
admitted.
what is your grievance?
We got a seat, my lord. In the third round of counseling also, my lord, we have been permitted to give our options, my lord. In the third
How
round.
can the candidates who have been allotted seat can give option?
The Supreme Court will not the.
All right, let's see.
In the third round also, we were given options, my lord. My lord, here.
So
the
when was 1 minute?
Lordship.
When have you given option?
My lord, the third round took place.
When third round of counseling has been held?
Third round took place on 4th and 5th, my lord. 4th and 5th of October 2023. Well, after this, my lord, your lordship will find at page number 24 a list of not reported candidates after mop-up phase of counselling issued by the second respondent. 24, my lord. This is issued by the second respondent, my lord. This list, my lords, your lordship may kindly see list of not reported candidates after mop-up phase of counselling as uploaded by principals of colleges. But this is the thing, my lord. Your lordship may kindly see in this list, my lord. Under the heading, my lords, ACOL, my lords, and ACRS. My lord, this is college. The next one is the PG course, my lord.
Whatever. So,
my lord, these are what
they have prepared a list. So what? Thereafter what?
What I am trying to demonstrate here is pediatrics in Gandhi Medical College, DVL in Kakatiya Medical College, pediatrics in Kakatiya Medical College, pediatrics in Mallareddy. These are all cream seats, my lords. These have been left. These are left vacant, my lords, and they were not even available for us to make options during the mop-up phase of counselling. We were permitted.
Stray wickets.
Mop-up. This
No,
is mop-up counselling. These were not allowed.
No. Master, what is your grievance? I mean, that you have been allotted a seat, then you given this thing, participated in the third round of counselling on 4th, 5th October, then what happened?
My lord, these other, as per this list, these candidates, I'm referring to these candidates, my lord, at page number 24 onwards. These candidates, even after getting a seat in All India quota and in the neighboring state of Andhra Pradesh, went ahead and joined in Telangana, thereby blocking the seats.
So, where have you said these people? They are not parties. They are not parties in the writ petition. No order can be passed against them.
I'm not seeking an order against these persons.
If you want admission against the seats allotted to them.
My lord, they have vacated and they've gone, my lord. I am not seeking any order against these individuals.
Vacated? You said that it has been allotted to them.
No, this list of not reported candidates. That means they have left these seats, my lord. They have left.
Please be clear. What is your grievance, mister?
My lord.
So now which seats? This all has to come in the writ petition, mister. It's not a storytelling, right? Which paragraph you have said? How many seats are this thing? Vacant. Where it is vacant? Where?
Lodge may kindly see para 2 itself, my lord. At page number 13 of my writ affidavit, para 2, my lord. Page number 13, para 2. Right from. My lord, it is submitted that the petitioners are challenging the inaction on the part of the second respondent in failing to take appropriate measures and failing to prevent candidates from the neighboring states of Andhra Pradesh and other states from participating in PG medical admissions 23-24 competent authority quota, third phase or mop-up phase of counselling, who have ultimately failed to report after the said counselling, resulting in blocking of 164 medical PG seats in the state of Telangana. The further action of the second respondent in failing to rectify the aforesaid mistake or omission on its part and hastily proceeding to conduct stray vacancy phase of counselling instead of conducting additional mop-up round of counselling, so as to ensure that the aforesaid 164 seats which fell vacant are filled on the basis of merit and not on chance or luck. This is my case in a nutshell, my lord.
Nutshell. It is as vague as it can be. Prevent candidates from neighboring. All right, you want us to that's it.
Gotcha.
That is.
My lord, what the relief I am seeking is now they have
give the seats in Gandhi Medical College in dermatology. This is the relief. What else?
Gotcha.
Huh? You want in dermatology in Gandhi Medical College next to your
because
house.
I am more meritorious, my lord.
What is the prayer? Please.
Prayer, your lord. Prayer at page number 17, your lordship may kindly see. Therefore, writ of mandamus setting aside postgraduate medical admissions under competent authority quota notification for exercising web options for stray vacancy phase of counseling dated 14/10/2023 issued by the second respondent and consequential allotment orders
No,
passed
so
thereunder.
like you are challenging this thing, no? Setting aside postgraduate admissions, whose admissions? You are saying I am not seeking setting aside of anybody's admission. The relief is setting aside admissions under competent authority. Whose admissions will be set aside? Of those people who are not parties. What is this? All right, thank you. Yes. The petitioner. Now, what can be done? We are dismissing for non-joinder of necessary parties and absolutely vague allegation. We told him twice. What else can be done? We cannot convince him and make him draft the application for impleadment.
In fact, he has
The
questioned,
petitioners are,
in fact, he has questioned the notification. Notification, Lord, page 20, notification has been issued by the Lord University.
No, no, you see, as we have understood, the prayer here is so complex that it requires interpretation, right? So, but what we gather is that he is setting aside postgraduate medical admissions under competent authority quota, setting aside of admission of students who are not parties before us. How can we grant such a relief? Yes, the petitions. So like this always this of getting something better. Like, Mr. Rao. You have filed. What is the urgency?
The bank accounts of the company were freezed.
Huh?
Bank accounts of the company were freezed.
Tomorrow. Item 1. Writ appeal. Yes.
It's a case where petitioner was sought to be interfered with possession of the petitioner. But the learned judge dismissed the writ petition only on the ground that there is only a mere apprehension. One aspect which I wanted to point out, Your Lordship, may kindly have a look at page 142.
What?
This is a subsequent event. They themselves have now issued notice. But the writ appeal can be disposed of by direct. We have given a reply, my lord. Let them consider and pass appropriate orders. At page 142. This was on the date on which the writ was disposed of.
Yes, correct. Fair.
Page 142.
142.
This is dated 11/10/23. We have since given a reply.
All right.
And this writ petition was disposed of, saying that is only a mere apprehension. This is on 11/10. Same day we received it. So let them consider, let them hold any action that they want to take only after passing any orders and hearing.
Yes, correct. This intra-court appeal has been filed. Mark the presence. Ah, yes, Mr.
Not page number 16. Page number 60.
60, 60, 16.
Page number 29.
29. 29. Item 2 and 3, Madam, certified copy today. That case also, can you type it? Yes.
I'm sorry, my lord, standing, I could not represent this.
Ah. No, but see, what is like, what has happened, Mr. Advocate General, their case is that this petition was filed on the last working day. You issued an order regularizing services of 5,000 employees. And now what he has filed another IA, your counter is awaited.
My lords, please, my lords, in fact, my lords, subject to lordship's view on the matter. My lords, already this honorable court has seized of the matter in an identical challenge. This court has taken the view of for that, my lords, and passed an order. My lord, this is, in fact, it's
which WP?
This GOMS 16 is, my lord, it is a statutorily encompassed under section 10A.
So, but he has challenged the validity of that provision.
Correct, my lord. That the counter is required to be filed, my lords, an identical challenge made in the back of cases.
No, he had no objection. This thing, he did not say anything about you can file counter. What he said, he has filed an IA. That is IA number 3 of 23. So what he has said that now you have issued various GOMS and you are trying to regularize services of how many people?
Then 5,545. Now, my lord, on 4/9/2023, proceedings I have filed memo, my lord.
No. What has been done? Order of regulation.
They are calling for the particulars of the candidate who are coming.
One minute.
I'll just.
What?
My lords, section 10A of my lords. AP Public Employment Regulation of Appointments to Public Services and Rationalization of Staff Pattern and Pay Structure Act 1994. My lords, Act 2 of 1994 enjoins, my lords, the power to regularize the services of certain employees. My lords, there is a, my lords, it is specifically stated as to who services can be regularized. Broadly, my lord.
Another issue was whether now, in view of subsequent developments, can you do it now?
My lords, in fact, my lords, this was already observed, my lord. This,
which petition?
11643 of 2023.
Please see. Please give.
Regularization, my lord, the statutory power is under section 10A, the amended provision of the Public Employment Act.
No, correct.
That need to be, my lords, that need to be decided, my lords.
No, but see, last time also we had given you time. What he's saying is that pending, what happens if they pass another order regularizing?
My lord, your lordship, that is always subject to your lordship's view, my lord. Your lordship may kindly take this order, my lord. This is the identical challenge. GOMA 16 is of 2016.
So that's what we were saying, that till you file reply, don't do it. Similar order.
See, my lords, any appointments, my lord, they cannot be deprived, my lord. Find 1,000 employees who were rendering the services in the sanctioned force.
No. Regularization process may go on for remaining, same shall not be finalized till next date of hearing.
Further, the appointments made by the respondent shall be subject to the further orders of this court.
Same shall not be finalized. We will say that it be not finalized till you file counter. You file counter.
We will certainly file counter, my lord. There is a batch, my lords. In other cases, my lord, in this particular petition,
we will list along with this petition.
Along with this, my lords, what will hamper is the persons in their legitimate expectation for regularization may not be deprived, my lords. That may not be.
No, that's correct. But the only thing is to the extent of illegal appointments. I mean, regularization should be done. But
regularization, yes, my lords. Regularization in respect of
those who have been
otherwise eligible to be regularized. That is, my lord.
His grievance is only in respect of illegal backdoor appointments.
My lord, that can never, the state can never do that.
Can we say so? that you say
My lord,
that.
GOMA 16, my lords, under rule 10, under section 10A, the regularization power is vested with the government as to what classes of persons services can be regularized. In fact, the GOMA 16 is also filed by them, my lord, that is.
Which page?
In the writ petition.
Page 17 to 19.
Huh?
Page 17 to 19.
Page 60.
17. In the IA 3 of 2020.
In the writ petition, page 68.
Very.
This is the substantive, my lords, the amendment made.
No, correct. He is challenging the validity of that provision. We understand that.
Correct.
It's not by way of an executive order. It's an exercise of statutory power. You are doing so.
Correct.
He has challenged section 10A.
Your lordship is correct.
Yes.
Who are otherwise eligible under this GO, my lords, their services are only, their contractual employments are only regularized.
My submission, my lord, once this court has taken the cognizance of the issue and issue notices, they accepted the notices, given undertaking to file counter. One hand,
No, but this order is there, right? Similar order, appointment shall be
Lordship, I kindly consider it. This is the 4th May 2023 order. They cannot be finalized. Now the proceedings issued by the second respondent instructing the fifth
So
respondent.
what is your claim? You are seeking substantive. You are also what is your claim? This is not PIL, right?
I'm entitled to be, once they notified, my lord, I'm eligible and entitled to get appointment under, this is a violative of Article 14 and 16 of the Constitution. I'm open market candidate, my lord, they could have been notified. That is my humble submission.
Acha, you are not an employee, right?
Not an
You are a
employee.
person aggrieved. You are saying that by regularization, my chances.
Is getting lost because there is no recruitment for the post since 2006 onwards, where some of them become age barred. One post there, 1 lakh people are competing for the employment for government side.
People 40 years, etc., are still eligible for appointment.
44 years. Government relaxed it, my lord, up 44 we are entitled to be.
Oh.
And the persons who belongs to BC, AC, ST, 10 years relaxation was there. Up
Like
to
they can
54.
up to 50 years.
54 years we are entitled to be, some of the petitioners.
Oh, even if you are 54, you can apply.
Yes, the government given such a relaxation.
No. So what is your age of superannuation then? Supposing if you
61.
join.
As of now, amendment 61 is the superannuation. Now, latest notification has been given for the.
So you will serve 7 years and get.
The condition incorporated in the notification, my lord, he may not attain the 61 years at the
No,
date
we
of
are
appointment.
trying to know, Mr. from you. That's a query, nothing to do. Like you can join this thing service at 54 and superannuated 61.
I am 40 years, my lord. All the petitioners is about 40, 41, my lord. We are entitled to work 20 years.
So we saw the cost title. That's why I query.
40 years, my lord. Upper age limit 44 years.
So why?
The government extended such a benefit to the direct
No, but
recruitment.
Mr. This is the order.
Order, my lord, they would have been restricted not to finalize. But they are calling for the particulars, my lord, that is my grievance.
The order. Which will pass the same orders. Those people who are already serving will also have legitimate expectation. The same order we will pass.
I'm bringing to the lordship's kind notice the proceedings. Lordship may
This is an
kindly
order in your favor, Mr.
Yes.
The proceedings, lordship may refer.
Mr. In respect of the process there is already an interim order, he has told the same shall not be finalized till further appointments which have already been made shall be subject to result and the process of regularization shall not be finalized. This is the order till they file counter. He is conceding everything. You need not oppose. Please
I am not opposing that. I am bringing to the lordship's kind notice. Once the order obtained on, granted by this honorable court on 5/4/2023, under teeth of this order, second respondent cannot ask for the particulars because it's seized by this honorable court. May I have filed memo mailed 104 of 230 of 2023. Lordship may kindly peruse one document I have appended along with it. That is dated 4/9/2023. Second respondent, second para, I'll leave it to Lordship's minute. The Commissioner of Intermediate Education, Hyderabad, is therefore requested to send the proposals in respect of eligible contract personnel who fully qualified as per service rules to the extent of available vacancies as per GOMS number 16 dated 26/2/2016, read with C number so and so so and so.
once this honorable court sees the matter, it is not open for the second respondent to send and ask proposals from the fifth respondent who is the head of the department. They cannot do this. If they had done so, my lord, they would have been issued definitely one night they will issue
Please understand another aspect of the matter is what you are seeking is stay of a statutory provision indirectly.
Yes.
That's what. Can it be done? What cases?
My humble submission, lordships would grant it
We will
status
give
quo.
you 5 cases where the Supreme Court has said deprecated the practice of suspending statutory provision. Statutory provision, Mr. indicates the will of legislature. It has not been struck down.
My submission. Earlier also I have submitted
Just a
before the
minute,
lordship.
1 minute. I mean, see, the object is to object of the, had you been reasonable, we would have understood. We would have, if you would have said that, sir, reserve post for us petitioners, you want to stall the whole process. If you would have said in the application that we are 16 people, we are eligible, we will lose this thing, please ask them to reserve 16 posts, understandable. But you want to stall the whole process. You can't be appointed against 1,000 posts, 16 people.
I'm humble
See,
submission.
what this thing?
I'll deeply oblige to the lordship's observations, my lord. But statute cannot be suspended. My humble request, my lord, the proceedings which were now issued, where the matter is seized before this honorable court, unless until this has been decided, they cannot proceed further the matter. 49/2023, if lordships have considered.
We have understood, right? That it can't be, they can't regularize anything. Even if you are 16 people, for all posts should be kept vacant for you. All departments.
I'm sorry.
You can join anywhere.
Only
So
the
you feel
education
like-
department. Lordship so pleases, I'm corrected to myself.
We are just trying to examine the reasonableness of it. That's not the prayer. You have not argued it. We said that if you would have, you want to stall the whole process. Why? The provision of law stands in their favor. It is being done in exercise of statutory power. This validity has to be examined. They have to be given time to file counter, and you want the process to be stalled. We are telling you that there is an order in your favor. Despite that, you are not satisfied. What else can be done?
I'm not satisfied.
Interim order, the principle of parity applies.
I go by the lordship's direction, because lordships are extended same, but I want to bring the lordship's kind notice. The things they are taking up, that is my entire endeavor, how they are doing. Once the order is there,
Your
they are doing.
grievance is confined to 16 posts only prima facie, Mr.
Lordship is extended, my lord, the same order and the 16 posts may be reserved for ourselves, my lord, in the recruitment process. I'm
happy. It's not question of being happy, Mr. The whole process is what, whole process is, it's very simple. You take it personally and something like that. But according to us, it's very simple. Whole process is trying to find out a solution to a legal problem within 4 corners of it. That's simple.
But once, if lordship.
We are not against you, but we are trying to test you the proposition that whole, this thing, even though government is exercising statutory power, even though you are only 16%. The relief is, see how disproportionate. That entire process should be put to grinding halt in the state because you want it. Why?
I'm sorry.
This is unreasonable, no?
Obviously, lordships have directed to reserve 16 posts, my lord. I'm happy. And one more.
Directing means we said we are not directing. But that
may extend the same
we are
order,
just,
my lord.
we are just like it's a discussion, right? Debate on the point we have told. It's not your prayer that 16 posts. You can't say that now I have said that, so therefore 16 posts should be reserved for me. Which reservation? How are you eligible? What is it? This is just an apprehension. Have you ever applied?
We are entitled.
No, tell us. Where have you applied? Which recruitment
If
have
there
you
are being
participated?
recognition like this, my lord, there cannot be any direct recruitment.
There has to be. This is again this thing, Mr. Petition, based on a mere apprehension. We can. What is it? What is this thing? Actual data to show. Which process have you this thing participated?
They are not even notified. Since 2006 onwards, all the posts they are going to regularize. There is no unrestricted post. Only 6,000 posts.
How can this be, Mr.? There is no direct recruitment in state of Telangana. How can
the posts of junior lecturers since 2006 onwards, there is no direct recruitment at all. That is my
No, you have showed us different departments. Now you are saying junior lecturer. And somebody you
I'm
said office assistant
kindly
in the
consider
pre-lunch session.
the
So
my
are you,
amended-
therefore we said, rightly told you, no, that
Lordship,
16
may kindly
posts in all departments in the state, everywhere should be kept vacant.
I have filed GOs of higher education, technical education and collegiate education, with which my claim is related to. I have not stalled any other departments.
Sir, this memo, what you are now referring, dated 4/9/23.
Yes.
They're only sought for information, only it's the proposals.
I read, I stand corrected myself. The proposals, once they send Miller, they will issue GO. What was happened in GO 38 is concerned. The same thing.
Please hear the question. There is no any positive direction. It's only they're seeking information. They're asking to give the proposals for further course of action.
Yes, that is my humble submission.
What is wrong with this? What is wrong with this proceeding?
28/4/15, they have issued some.
1 minute. Interim order saying that statutory provision cannot be stated. PLL. Statutory provision cannot be stated. We have relied on case law. In Mr. Krishnaiya's case or somebody else. Give that order. Yes, please.
Within 2 days, Miller, they have issued n number of GOs regularizing the candidatures. Election code would have been intervened, Miller. Otherwise, they would have been issued the GO. That is my humble submission. They cannot use it.
Please read
Once
the order.
They have taken time.
We have taken note of that. We have taken note of that. Please read the order and the memo. This memo has been issued in furtherance to this order. Please read the order.
Process may go on, but not to finalize the Lordship's order, Miller. This Honorable Court orders. They have issued, but they cannot issue GO finalizing the same. They cannot issue GO further.
Just 16 people cannot hold. We will not agree with this one. Whole process cannot be. How can it be?
They cannot finalize. Basing on the even proposal submitted by the fifth respondent, they cannot finalize pursuant to the under teeth of this Honorable Court's order.
Sir, the further orders are all subject to the outcome of the writ petition.
That is the observation is there. But finalization also is one of the limits.
How are you agreed with it?
I leave it to Lordship's discretion, Miller. I brought to the Lordship's kind notice regarding the irregularities taken by the government side.
The provision is yet to be, Mr. Please understand, you are proceeding on the assumption that it is illegal. The validity of statutory provision is yet to be adjudicated in the writ petition filed by you.
But they
have yet to file counter.
Yes.
Nothing happens. Don't worry, we will, Mr. In case provision is struck down, this court has power to direct that 16 posts be created and the test is held for you and you participate. Right? And if you are qualified, then you will be given appointment. This power is always with us. Nothing happens with this. The statutory right cannot be defeated at this point of time.
I'm sorry, I'm not wasting the time.
No, not wasting. We are hearing
A
you.
proposition I want to submit, Milord, once notice ordered, they ceased they ceased to proceed with the matter. What is the observation of the Honorable Apex Court, Milord? I'll bring to the Lordship's kind notice and then I'll leave.
What, my lords, my friend has misconceived of my lord, the
Please, let me
Supreme
come.
Court has
Advocate
seized
General
from
may be
a
allowed to
matter.
make submissions, Milord.
My lords,
Learned Advocate General, please to allow me to make my submission.
No,
Then we
not
can
please.
debate.
We are permitting you, but say something. He's telling
Because
something about
once Lordships have accorded permission, Milord, he is coming in my way. That's why I make submission.
coming in
Page
by
22
There's
Milord,
nothing. He is not coming in your way. Don't perceive him as your this
I'm
thing.
sorry.
Not
It is very unfortunate that I read it. Apex Court
Where?
observations. Page
What?
22 of the IA. IA 3.
the interim order is referring.
unfortunate. What? IA3.
Once
What is unfortunate? I mean,
the observation of the Apex Court, Milord, it is not my.
no. What? In this case.
In the similar case, Milord, the Apex Court order notices
All right.
not to proceed with the observation taken, Milord, they would ought not to proceed with the matter. Once they proceeded, how the Supreme Court dealt with is the question.
Yes.
It is unfortunate that despite the fact that the respondents, more particularly the state government, was aware of the present proceedings, and fact that in the present proceedings, this court made notice returnable on 28/4/23. The state government have issued the promotion order dated 18/4/2023 after receipt of the notice issued by this court in the present proceedings. The promotion order dated 18/4/2023, even the state government has stated that The promotions which are given are subject to outcome of the proceedings. We do not appreciate the haste and hurry in which the state
That we know. Yes.
has
So,
filed
1 minute, mister, 1 minute. What are the educational qualifications of the petitioners?
Petitioners having, my lord, the
Graduation.
postgraduates, my lord, they are postgraduates.
Acha.
And they have passed
And
net and
so
SLET.
1 minute. So postgraduates and which recruitment have you applied in the petition? No
It's my
recruitment.
I am qualified, my lord, there is no direct recruitment.
No direct recruitment.
Posts.
All right. No direct recruitment. Acha, so contractual appointment is all made backdoor.
Backdoor.
All right. So then which department you are desirous of? There are so many departments.
I am concerned with only education department. I am
Which post
intended
you
for
want to be
junior assistant, junior lecturer, degree lecturer and occasional lecturer.
Junior lecturer.
Degree lecturers.
Ah.
In government degree colleges, junior colleges,
Government degree colleges.
Yes. And occasional lecturers.
Degree colleges in
Occasional colleges.
education.
Occasional lecturers in occasional colleges.
Occasional.
Occasional.
Vocational lecturer in education department, correct? So this process, all 5,000 posts of junior lecturer degree, government degree and vocational has been filled up.
Only
5,000 posts.
Total cadre strength is 6,200 and odd.
Acha, total cadre strength of these people, junior lecturer.
All the posts, 6,200 and odd.
6,200.
230 something is there. 6,200. Lordship may kindly consider.
6,200. Then out of this, how many posts have been filled up?
They have filled up, Millard, according to them. 30, 24. Recently by GO, Millard, it is a personals of 5,544 posts have been filled. 5,544.
Filled up.
Filled up.
When?
This was on, Millard, 30th April 2023.
And then now how many, 500 something, how many posts?
900 posts are there, 700 posts are there, 700 and odd posts are there, Millard. For that also proposals have been called for on 4/9. In the open market.
So your prayer is that no regularization should be made because you have challenged the virus of section 10A.
If all the posts have been filled up, Millard, there is no post for direct recruitment. That is my humble submission.
No, but do you doubt the powers of this court to create 16 posts and to direct?
Inherent powers under 226, Millard, the court can do anything.
Do it, anything. No, not anything. Anything in accordance with law.
Permitted under the rule of law, Millard.
Yes,
That's
not anything.
Subject to that.
We can't. I mean,
my submission.
Many things we can't do. Many things we can't do under article, even under article 2. Yes.
I'm sorry.
No, it's not sorry.
In accordance with the rule.
We are trying to understand. So there's nothing. That's it. Anything else?
30% posts should be filled. 70% allocated for direct recruitment and 30% by appointment by transfer is the rule contemplated under the presidential order. Zonal, multi-zonal, these two posts are coming under statewide as well as the multi-zonal. So 60% of the state posts and 70% of the zonal cadre, multi-zonal cadre to be filled by direct recruitment. They are not, they are, if that is the Millard, regularization by appointment by transfer they are doing, which is also impermissible against the presidential order as well as the statutory rules governing the posts. These are my submissions.
These are submissions on IA 3 of 23, correct?
Yes. They have said, Millard, by virtue of the orders, Millard, they cannot do. That is my submission.
Which orders?
Interim orders, Millard, and 5-4-4-5.
That was only till this thing, filing of counter.
IA 3, Millard, these facts are brought to the Lordship's notice, Millard. Lordship may kindly consider.
They have filed counter, right?
Earlier they sought time on 16/8. Then 4/9 they have issued a proceedings.
No, so why have you not, if it is in violation, then contempt? They have committed contempt.
In my case, I have filed, Millard.
Which interim order you are saying that they can't do?
Now the land AG has placed the reliance on double
No.
63, Millard.
Hey, Mr.
In my case, there is no interim order.
Then How you are saying that in violation this they could not have done? How, where is the, that's what we are looking at the,
Because
there is no interim order in your
my
case.
submission, my lord, the land AG placed the reliance now while making submission.
No, he is not placing reliance. He has been fair to the court to point out, which you should have done. He has pointed out that this similar case and interim order has been passed.
They know me not because I am the petitioner of this case. The respondents are from other case, they are representing me, lord. They 112.
So, according to you, this interim order should not be relied upon. Right?
I am not submitting.
Fine.
Once
So, it is clear that in your case there is no interim order, and therefore question of this submission that they could not have done it is incorrect because of interim order.
My case, 28th.
All right, we will record your submission. Mr. We can't prevent you from arguing, making an incorrect factual submission. So your submission is that despite interim order, in view of interim order, no regularization could have been made.
My submission, Millard, I have awarded in the IA also on 24/2023, notices have been accepted, notices were ordered to the respondent, they are acknowledged of the same. They cannot proceed with the matter because it is seized by this honorable court. It is nothing but as per the observations of the honorable Supreme Court, it is a process of overreaching the court. That is my submission. Once they
I mean, that's very good, right? So, only thing you have to do is not to seek stay in any case because issuance of notice will automatically result in stay of all proceeding. So, therefore, don't file IAS for stay. Then why have you filed this?
That is my submission, Millard. Lordship may kindly consider. That is my submission. It can be brushed off. But that is the observation of the Honorable Supreme Court, Millard. I am bringing to the Lordship notice.
Yes, that we are bound to deal with that observation. Yes.
That is the observation made by the Apex Court, Millard. I am bringing to the Lordship notice.
Yes.
Once notice ordered, they cannot.
So what is the observation?
Observation, Millard. Lordship may kindly come to para, Millard. It is penultimate para at page 22. It is also noted. It is to be noted that the selection.
No, this is Mr. In the facts of that case. You are not claiming, you cannot claim 700 posts in the education department when 16 in number. That vital aspect you are missing. You want to stall the whole process of regularization. This is not a case of that nature.
This is the matter of promotions, Millard. 70 people promoted, 3 petitioners before the Honorable Apex Court.
We know that it is the case pertaining to judicial officers.
Judicial officers promotions, Millard. Fine. Subsequently, final orders have been passed.
We will this interim order of Supreme Court 28/4. What else?
This is my submission, Millard. Once notice order, they cannot proceed. If anything taken, will be void of the. I'm sorry, Millard. It's a violative of the order, notice orders, Millard. That is my submission. Once notice order, they cannot proceed. That is my only submission in the IA also.
Yes. So then why have you filed this IA then? If the notice is there, so operates as a stay according to you. File a contempt against them that the August order of issuing notice, they are doing it. We will deal with such as then why there is no need to file IA if this submission is there. You realize? All right. Yes.
My lords, in fact, my friend has should have done some research on before he places reliance on the interim order passed by the Honorable Supreme Court. My lords, while a writ petition under Article 32 was entertained in respect of the judicial officer's case, there was an interim order passed by the Honorable Supreme Court on 13th April 2023 itself, my lords. In the teeth of the order, my lords, when despite the
13th April, now order was passed.
My lords, in fact, this is finally disposed of, my lords, as per the interim.
That is reported. I'm sorry, Millard. That is reported to full bench, Millard.
1 minute now. We have heard you right for 30 long minutes, like from 3:45 to 2:45 to 3:15. Let him speak for a while.
My lords, page 5.
This you should not do. Citing an interim order when the case is finally decided. Yes.
My lords.
That's made absolute, Millard. That interim orders are made absolute.
Page 5.
Please wait, Mr. Please sit down. We only can request you to sit down. You have, still if you want to say anything, please don't interrupt like this. Has to be there's nothing great about this order. It's not that you are seeking a review of Keshwan and Bharti and we are not deciding what is fundamental right. Plain and simple. But you are making it a prestige issue. That's the problem.
I'm sorry, Milord, I'm so taking any personal.
Any this thing, please, if you have any submissions to make, please make it now. There, after learned advocate general is finished, you will have a right of reply. But there has to be an orderly. He can't be like this that he speaks one sentence, you stand up.
I'm sorry.
Please have patience, note down, and then answer. We will hear you again in reply. We are not in a hurry. What to do? Any other old case would have been heard, but this is more important. Yes.
My lords, my friend, my lords, essentially relies upon the interim order, my lord, saying that since the court has seized and a notice has been ordered, my lords, it's totally misconception on the part of the petitioners.
Yes.
My lords, how the Honorable Supreme Court has dealt with an order, my lords, which was passed on 13/4/2023 at page 5 of this judgment of the Honorable.
Final order.
It is final order, my lords. As for the interim order which my friend has relied upon,
13/4.
page 5.
So that was in violation of an interim order. That's why Supreme Court said.
View that despite passing of an order, it is not mere notice.
Yes, correct.
The Supreme Court prima facie found.
Correct. Yes. Next point.
In that context, my lord,
yes.
Since the above object under the GO issued is, my lords, to regularize the services of contractual employees who were otherwise eligible to be appointed, had there been, my lords, a recruitment process. The government has fully met the qualification criteria, the eligibility criteria, and their uninterrupted services in the matter of education from 2nd June 2014. My lords, my friends, I do not know why didn't they join at all in the contractual employment of service if they are really.
No, he has not joined.
They didn't join, my lord. If he is an aspirant to do some job.
Some job. Is
He
the
should do
grievance.
some job.
Grievance is that you are not issuing any direct recruitment for director in this appointment. That's the problem. He is unable to
After
apply.
confirmation of the state of Telangana, the notifications issued. Probably they must have been, my lord, eligible for various competitive exams. My lord, this is nothing but, my lords,
All right. So how much time you want to
my lord,
come?
my lords, after Dasara vacation, subject to lordships.
2 weeks time shall we grant?
3 weeks time, your lordship. In fact, the substantive counter is filed in the other writ petition, identical challenge, my lords.
Yes.
We will cover some more aspects in the counter for your lordship's kind consideration. My lord, your lordship may kindly consider my sincere request because, my lords, the employees in their legitimate expectation, whoever, my lords, otherwise eligible under GOMS 16, there is a avowed cause. They have been rendering in the services of various governmental institutions in the noble profession of teaching, my lords. If they are really interested, my lords, they should have joined some position, some post, either in private or in the government sector. This is to stall, my lord. There is no, the cause espoused is not the real cause, what they wanted to achieve, something else, my lord. This is apparent from the manner in which the writ petition is filed and also the argument advanced. I therefore pay this honorable court, my lord, there is, your lordship may consider time, we will file the comprehensive counter for your lordship's adjudication on section 10A itself. The substantive statutory provision has to be dealt with by your lordships, my lord, in accordance with.
All right.
I'm grateful, my lords.
My humble submission, my lord, they cannot proceed further, my lord, by virtue of the interim, if the Reliance placed 11263 of 2023 dated 5/4/2023. In another case, my lord, where the same challenge has been said to have been made by the other petitioners are concerned. They cannot finalize the things, my lord, basing on the 4/9/2023 proceedings which have been directed by the second respondent to the fifth respondent. That is my humble.
No, that is not your argument. That he referred. We will decide what to do. Your argument is they can't proceed. Anything else?
That one thing notice, my lord. The second thing is interim orders now they placed.
Huh?
They cannot finalize, my lord, in the identical.
That you have said, right? How many times? Supposing if we ask you to sit down and sit up again, you will again say they cannot finalize, cannot
I
finalize.
don't have any rebuttal, but my submission, my lord, the interim orders which are, the notice, earlier interim orders were not granted.
We have understood, Mister. You have relied on an interim order passed by Supreme Court.
My land agent is pleased to submit, my lord, that is interim orders granted apart from the notice. That is not the case. Only notices were ordered. Within 10 days, it has to be returnable. In the meanwhile, promotions were taken place. The hurry and hasty manner has been discouraged by the honorable apex court. There is no interim order granted not to proceed further. There is no order to that extent in that case. And that was interim orders are made absolute, my lord, by suspending the GO. The promotees who are sent for training, the training could be completed, but the posting which were given have to be not to accommodate them is the order of the apex court. While referring the matter to full bench in
This is not your case, Mister. You are not seeking promotion. Please understand. This was a case pertaining to judicial officers with a definite right of a promotion. You have this thing, dim prospect of being selected in some process.
two things,
right?
Two things land age is submitted, my lord. One is interim order is there, and that is the final order. These two things are not correct. Interim order is not there.
Not there.
And final order is that matter referred to larger bench. That is full bench, my lord. Lordship may kindly consider. For interpretation of the rules are concerned.
No, you are not a judicial officer. This is not state of Gujarat. Nothing. So it has nothing to do with the case of facts of the case.
Same, my lord, but interpretation, my humble submission. How the
What like this is the section 10A similar provision like section 10A was challenged in Gujarat case. What is the submission?
To taken a notice of a cause, can the authorities be proceeded for the matter? Is my submission.
That you have told us. We have
is my
noted down. That rejoinder doesn't mean that you will repeat what all you have said.
Two things were not there, my lord. That is my humble.
Please see, Mister, the order which we will pass is subject to your right under 136, correct? But this we cannot go on. Like we have been patient. That doesn't mean you will repeat whatever that they cannot pass. They cannot pass. 10 times you will say. We have noted down. We have noted down. Anything else?
But these are my submissions.
Thank you. Please sit down.
No bloods.
Heard on IA number 3 of 2023.
IA2 also. The respondents implead petition, my lord.
They have been served?
They have been.
Madam C, if they have been served, it can be allowed.
Notices were ordered through court.
Will, so then, right in the beginning, what is IA2 served? Nothing is there. We will, it is pending. So you say appropriate orders on IA2 of 23 shall be passed on the next date of hearing. Yes.
I am deeply obliged.
Yes. Nothing, mister. We are doing our duty.
I'm sorry.
Yes. Nothing. Thank you for your.
I am deeply obliged.
Yes. Yes.
There is construction, illegal construction is going on, your lordships, every day night. The illegal construction on the Shikam lands, pond lands.
So it will be given to you along with the land, along with construction.
You will have not claiming that.
We know that it's a PIL. Later, when we say something, don't take it so seriously, Mr. So what they are making improvements on the land. It belongs to public. It belongs to you also. So it will come along with that construction. He will not claim any equity. Why are you raising construction, Mr.? But how can we decide what is the nature of a land here in the petition?
Admitted by the respondents, they all the respondents.
Who is appearing for respondents? For? No. What is happening? This 10, 11.
10, 11 is the FPTC and Sarpanches, your lordship.
No. 10, 11, 12. These are the respondents who are raising construction. Who is raising construction?
12 your lordships, where he was just released. Before that, he was in jail since 2 months or 2 years. Construction is going on after.
At present, central jail. What I mean?
1 week.
He is carrying on construction from central jail.
Yes, 1 week back, he was released, your lordships.
He is in jail. No, what has happened that, see, have they been served? Like respond number 12.
Served, your lordship. I have filed SR also.
1 minute. Madam C, respond number 12. You are appearing.
10
and 11 minutes. Respond number 10 and 11, I am appearing minutes.
So you are not raising any construction.
No minutes, we are not minutes.
10 and 11. And what about you? You are also not raising any construction. R9. And you are also not raising any construction, right? No, you are not raising any construction, right? For purposes of IA. What about you? You are not raising 1, 2, 3 and 6. So what is the construction raised by?
Temple constructing in 2 acres lands, your Shikam lands, pond lands, FTL lands. Temple is constructing your lordships without any permissions. Where I have made
no, but like temple, I mean his own temple, respond number 12 or God's temple. People construct their own temple also.
Kindly see the
like,
Tahsildar report.
No, why, Mr.
Yes.
Interesting thing, right? It's a public interest litigation. 1 minute. Public interest litigation. Then respond number 12 happens to be a political leader. Then he is in jail. So which God he is like a devotee of?
His personal interest, he is constructing your lordship by managing the official respondents. They admitted that it is the illegal construction, no permission.
Yes.
They are not traced that who is going to construction. That is the counter.
1 minute. So which authority is required to supervise the construction, Mr. Gram Panchayat. You are there. 1 minute. You are, if any, this thing within your jurisdiction, if any construction is raised, you are, 1 minute. No. Please listen, Mr. We are just trying to comprehend the compromise. There is nothing like, so public interest litigation. So you are against petitioner, so therefore you will say no all the time. We are asking you, then we will say that in case you are unable to this thing, no means then it's a fit case where you are an elected body, right? We will ask the government to supersede you under Gram Panchayat Act. Must be provision. Because you are saying that it is not my duty to prevent construction, like regulate construction. You are saying, so that means you are unable to discharge your statutory duties, fit case where you should be dissolved. Right? We said, we will say that you are saying that, no, we have nothing to do with construction. We cannot regulate the activity. How can you listen to the query?
Sorry, ma'am.
Listen, I mean, it's we just trying to find out, not against you.
I'm sorry, ma'am.
Why? So see, Mr. You are under a statutory obligation to ensure that whatever happens in the limits of this thing, it is done in accordance with law, including construction, right? So whether respondent number 12 has taken any permission from you for raising construction. One by one, it's simple. The answer will be itself. If you ask yourself correct questions, you will get the answer. So has he taken?
So, of course, Gram Panchayat is considered, it's not given any permission, but Gram Panchayat is concerned, it is not given any permission, page number 3, point number 5, by counter. We are not given any permission.
Not given. So according to you, illegal construction is taking place?
Yeah.
Huh?
Question. Ask. On what basis you are saying that these constructions are going on in FTL?
Pardon, Your Lordship?
On what basis you are saying that these constructions are going in FTL?
Your Lordships, 2 days before, Your Lordship, they have dumped the bricks and cement bags also, Your Lordships. 2 days back.
No, Mr. One more thing. We are just finding out what will be the order. It's different thing. But if the construction is state, you will have to own the responsibility of cost of escalation and deposit the amount. We will not permit you to go scot free. This is one of the conditions which we may impose. We are not guessing, right? So what happened, madam? Respond number 12 has been served.
Yes, Your Lordship. SR number
Sir.
59463.
When?
14/7/22.
14/7. He has been served. 14/7/23. No. 14/7. 14/7/20. Government teacher enlighten the large number of people. Yes, again, paper publication. Articles. I think it's stated in this and it's given in the FTL. This I was going through this petition. One minute. See, this is the answer here. Respond number 12, brutally killed. So he has killed your son, that's why you are filing the petition against him, right?
Earlier also I have filed your
Para 16.
Yes, I stated, Your Lordships. Why? Because by court judge they have murdered couple of advocates, Your Lordships.
Where is this? What like murder? This is not, this is a motivated PIL. That's what, like you have said, otherwise we would not have known. You have said that I have filed this thing, he has killed my son, and that is not our job to hold investigation in PIL and to convict him and this thing, right? But I mean, we got it that why you are at after him. Paragraph 16. See, he has been repeatedly making representations. Nothing is, why don't you respond, mister? Hey, but who are you? Hey, third respondent. What third? Who?
District
So we should, I mean, you are only say third respondent. We should this thing. No, it's our duty, mister. Correct.
District
No, you are correct. It's absolute our duty. You can say anything and get away because we have to write order. So every time we should look at the cost title and find out for whom. You cannot tell the name of the person for whom you are appearing.
I stand myself corrected, my lord. I am for district panchayat officer, my lord. Supervising authority to the gram panchayat. For the gram panchayat is the 9th respondent, my lord. And we have received instruction and we have
Under which provision the gram panchayat grants the building permission?
under section 114, my lord,
Give madam.
of the Telangana Panchayat project.
114.
And my lord, notices are issued, my lord, and construction have been stopped, my lord. Those are my instructions.
Stopped?
Yes, my lord. I have filed my counter also, my lord.
He filed counter in 2022, your lordships. I have filed these photographs. I received your lordship 3 days before your lordship. This is the status, your lordship.
Yes, we cannot go there and stand like near this thing, land, and to see that no bricks are unloaded and all this. Right? Please understand.
I understood your lordship.
Yes. If you have anything to show, then they have already, I mean, they are, please understand, you may have reason to believe that respond number 12 has killed your son. That is whatever happens, we don't want to know in this public interest litigation. But please appreciate, this is a public interest litigation. The grievance is not relating to killing of your son. Grievance is on a government land, he is raising this thing. They are not contesting your claim.
Yes.
You are unnecessarily, feel agitated. They are saying, and that we have, where is that, Mr. Which provision? We are trying to find out the legal provision. Yes. Because we cannot go by this, that assume that he has killed and therefore.
Yes, yes.
Right, this is your outlook that who has killed and this. You seek remedy. That's not the case here.
Section 114, my lord.
114, approval of building permit.
Approval of building.
So, all right, 104. Then, which is the provision under which the panchayat has authority to pass an order to stop construction? Simple, right?
It's 115.
11. Yes.
If there is violation of section 114, my lord, they can proceed by issuing notices, my lord, and proceed for demolition, my lord, by the gram panchayat, my lord.
Which provision you will power to this thing, stop construction? Has to be like there is a provision. Must be. Limitation market committee, gram panchayat. Time entry. 120. No. Power to stop on this thing. Unauthorized construction. Notice of action.
Under subsection 8 of same section 114 only, my lord.
114. Subsection.
But in this minute, I filed.
So this is the exactly what it provides for your dissolution, Mr. If it is established that unauthorized construction has come up, the law provides for a consequence. You shall be liable for dissolution. That's what you are.
Lordship, I kindly see, my lord.
1 minute. This the.
So gram panchayat is empowered with the demolition by passing a resolution for granting.
No, which provision to? There is no express provision.
Permission as well as demolition is entrusted to gram panchayat by passing a resolution, my lord. They have to.
Who has passed a resolution?
Gram panchayat, my lord. It is a body, my lord. Elected by the.
That we know. It's an elected body. So they have passed the resolution.
Yes, they have to.
Giving power to you.
Yes. No, not. Panchayat secretary is representing the gram panchayat, my lord. They'll pass the resolution and panchayat secretary, based on the resolution, my lord, issues permission And as well as, my lord, if any complaint is received, my lord, demolition order will also be
No,
passed.
Mr. Babu, you have told us the provision. We are asking you in every local law, there will be a provision power to give notice to stop unauthorized construction. And then that law confers, we believe somewhere, everywhere the statute must be perimaterial. Then it gives power to seize that construction. Then eventually demolish it after giving a notice. Is there a provision in Panchayat Act? Not there. In Municipalities Act, there is a provision like that we have seen here, that there is a provision which says that seizure and this thing, demolition. Where is the other thing? Mr. You have filed the petition, right?
Yes, well.
Your role is over because it's a public interest litigation, right? You can relax after filing. You have lost locus in any case. So therefore, it is our job to find out what is the provision.
How to assist your lordship.
To assist, you are not assisting, Mr. Which we are asking you a question simple. We are finding it out for you. You should tell us, focus on the legal, forget about it, what he is doing, where is he, whatever. The issue is your case is on a public land. Is construction, unauthorized construction is being raised.
One thing. Another thing is the Shikam lands, which was reflected the counter of the Tahsildar. It is the Shikam lands, FTL lands, even though they have to protect. They are also admitting that it is the Shikam lands, but they are also not protecting it. That is my.
So we are trying to know under which provision, which authority is competent to take action. You have to tell, Mr. Don't leave it to us at the court. I will say these are two grounds. Let the court find out. Then we will appoint Mr. Prabhakar as amicus in your case, so that he can effectively assist. Mr. Prabhakar, please tell us what is it. All we want to know is that under Telangana Panchayat Raj Act, the Gram Panchayat is the competent authority, right, to regulate the building permission. So 114, right? So thereafter, under which provision it can stop the unauthorized construction? You tell us. You please relax, Mr. Sit down. Your job is over. Sit down. We have appointed him as amicus. He will assist us. Sit down. Yes. Which provision? Book you give him. Madam, give him book. Telangana Panchayat Raj Act.
Here, my lord, here the fact is, my lord, on Shikam land, government land, my lord, they are carrying out construction, my lord. The Tahsildar has to protect irrigation department. They have to protect the government land, my lord.
No, you don't have any responsibility. This thing is only to take salary from the government. You don't. Mister. You don't have any responsibility. Panchayat has to do it. He has to do it. You don't have to do anything.
I'm holding only supervisory jurisdiction.
That's
In fact, I have filed my counter also, my lord. Your lordship may kindly see my counter for a moment. For a moment, my lord. I have filed
We are asking some question to you. Please answer that. If you don't know, sit down. If you don't have to do anything, then why stand up? Sit down. Yes, Mr. Panchayat, under which provision? How will you, supposing if an unauthorized construction is being made inside your jurisdiction, what will you do? Under which provision?
Lord, I have to see, Lord. Primarily, Lord, we have not given any permission for construction of temple in survey number, Lord, which is mentioned in the sprayer.
No, but his grievance is construction is being made.
No, I have
it
made.
has to. You have to ensure that it is.
Lord, in my counter category change, Lord, we have not granted any permission for construction of temple in the survey number.
No, then you must ensure that the construction is stopped.
But we have not given any permission, Lord. Still, permission is not been granted by the Gram Panchayat.
And so then supposing if
I article said, your lordship kindly permit me my counter, my lord.
You should understand that if he has not granted permission, then if the construction is taking place, they have to stop merely saying we have not granted. Please tell him, brother.
See, in case if no permission is granted, what are the steps contemplated under the act? Have you done it? That's the question.
You have to do it. If he is raising construction, you have to take steps. Merely saying that I have not granted any permission is not enough. Please understand.
Lordship, grant some time, my lord.
What grant? So he is raising construction, no? Mr. Prabhakar, then what is the provision?
Under this act, my lord, unlike what we have under GHMC Act and other statutory.
There is no provision.
Here,
But then see, power to regulate means power to this thing prevent also unauthorized construction. That has to be implicitly read. Then it has to be incidental power, right? Under maybe with the aid of General Clauses Act, we can infer such a power. All other things to do necessary to make that power exercise of that power effective. This Telangana General Clauses Act, madam. General Clauses Act.
If we don't think to be joint inspection report by irrigation department and revenue department. Because this is the being constructed in Punta, shipping.
All right. No, but by the time inspection is done and everything, the complete construction will be complete.
We can direct. Generally, what happens will be in those.
No construction shall be made. All right. So, Mr. Prabhakar, what we intend to do is that the Gram Panchayat itself is saying that they have not granted any building permission. So we will ask the or some senior officer of revenue department and irrigation department to visit and to give us a report. In the meanwhile, no construction on this land.
But one aspect is if it comes under FTL, the Tehsildar is also under responsibility not to allow construction.
The same thing, 7th and 9th respondent have issued notice.
No, now we are issuing an order itself, right?
That's
Already they have issued.
Mark everybody's presence. Which IE? Hold on, IE. Yes, madam. Yes.
Don't think we'll be able to.
So after,
Only one small,
yes.
one small clarification that I wanted from the current AG. Under the business rules of the state government. So now because the respondent number 9 is an employee will be deemed to be under the state government. Now each state has framed a business rules insofar as the discipline inquiries to be conducted as against the IAS officers, IPS officers and IAS officers. So I have seen the line of judgments that every state government has got its own business rules. But unfortunately, Telangana government has not hosted its business rules on the website. I don't get any, because what happens is, under the business rules, the officer who is designated as the discipline authority, he is the one who is required to take all the steps.
Therefore, we should decide some IA, right? Please tell at least. Again, it will come up.
It may not be possible within 5
No, at least one IA we can decide.
Yes, I'll
Two of
But that one IA,
2007.
Your Lordship will see, IA number 1 of 23 in WA 686 of 17.
6.
686 of 2000. These two, you are not connected.
Subject to this last occasion, my Leonard friend told saying that all this can be taken up along.
No, not all. Certainly not.
Whatever you want, please submit.
Last time I did not say so.
Milord, inquiry is completed, government has to submit a report.
That's
all. After the report, Milord, he can raise all the issues.
That's
After
true.
the direction of this honorable court, special chief secretary has been appointed as a disciplinary authority and Milord, he has conducted the inquiry. The report is awaited.
The rule
is the direction of this honorable court.
The rule
Then he can make all the allegations.
I'll do it. But His Lordship wanted me to point out some IAs which can be closed.
Which can be
IA number
it's
1 of
repeatedly
23.
coming up.
That's why.
Repeatedly coming up despite an order that it will come up in January 24. Again, IAs, it is coming up. He knows several times.
IA number 1 of 23.
One of
WS 686 of 17.
1 of 23.
It is subject to corrections allowed already, receiving documents.
55. IA 1 of 23. Complete petition.
Of 17. This
there
is
is
to
some
complete response
complete-
number 16.
Who is 60?
He is the special secretary GAD. He is the actually disciplinary authority. So unless he is completed.
Why the
State of Telangana is going to be the chief secretary.
No, but
Head of the administration. The independent.
no, the charges in this case are being framed by the.
Authorities may not be really necessary.
No, this authority is framing the charges. That's why we said because any direction it goes tomorrow.
Is the inquiring officer, inquiry authority.
No, he is not the inquiry authority. I will not do that mistake of implementing the inquiry.
So have you filed objections to
He
this?
is the disciplinary authority.
IAs are being given.
He is the disciplinary authority, not the inquiry authority.
IAs will also be taken. I'll file a counter.
Let them file, Prabhakar.
Then it
Counter.
even immediately after vacations, 31st of October or something.
Yes,
Sometime in
31st,
October.
31st October is the earliest possible date.
Yeah, very good.
31st.
I leave it to you.
Mr. You can also, whosoever wants to, item
Yes.
55, Learned Mr. Harinder Prasad Learned. Let it go on the next date now of 3 minutes. So there's no point. So what date? Which date?
Date was already given, minute 6th.
No, not given. We have to give. We did not even mention some date. 6th
6th November.
6th November,
Yes.
right? Every convenient to everyone.
Yes.
So you mark.
Your Lordship's kind permission. Item number 68, my lord. Your Lordship, I'm being led by a senior counsel who has personal inconvenience for the next 2-3 days, my lord. If I request your Lordship to kindly post it on reopening day or any day convenient to your Lordship's.
Which case?
Item 68, my lord.
2005 matter.
Yes, my
madam?
lord, we are ready, my lord, but only thing is he's not available next 2 days, my lord. I'm really sorry for making this mention.
See, we wanted to finish all these cases in a mission mode
Any
and
other
so that the court is free of like cases up to 2010. But see, you will have to cooperate,
Yes,
madam.
my lord.
The
Only
problem is,
this
see,
one opportunity, my lord.
the only problem is why we refuse to adjourn. This thing is, if we grant you adjournment, we don't have any moral right in asking the council in item 67 to not to grant him adjournment and to argue.
Yes,
This is our predicament.
We've been ready, my
If
lord.
we are wrong, see, this is the, we lighter when we say that if we are wrong, we have to be consistently wrong. Consistency is the big virtue for a judge. If we are wrong, we have to be consistently wrong. If we have, supposing wrongly, we have assumed this practice of not adjournment, it has to be followed uniformly. Why don't you prepare? Let's see what is the matter.
One opportunity.
No. Why don't you prepare? We would like to hear you. In case any, let it be in the list. In case we come to the conclusion that maybe that you have a good case, so you may succeed on your own, then your senior won't mind.
Yes.
And in that case,
Only thing is, my lord, clients are insisting on.
insisting.
1964 award.
In fact,
He has come running. Yeah, now we have got it. So we will see tomorrow.
in fact,
Tomorrow can be a different day. We don't.
item 67, I'm appearing, I would have no objection.
Huh? No, Mr. 60.
67, I am appearing.
The only thing is that these, as we told you,
In fact, I have some inconvenience tomorrow, but your lordship would permit me to log in through online. I may not be able.
let's see whether it reaches or some other case may go on. We don't know how we have placed. Let it be on the list. Like we will, any of your junior can. All right. We will. There's no 1 day is no problem. We'll do it. But let it not be. See, this is what.
I'm sorry, my lord. I'm really sorry, my lord.
See, this is what. How can now he is praying for adjournment?
No, not for adjournment.
You want to withdraw a case?
Its impact was that.
That's so very good. Yes, you should say that. We thought that you are feeling inspired by her and seeking adjournment. Not at all, no. Which case item?
Next, welcome representations. For a change, our WhatsApp next, welcome representations.
Yes.
63 and 64.
63 and 64 infructuous.
Yes, ma'am.
Oh, great. 92,095 petitions. See, item 63. We hope that you are for the petitioner, right?
Yes, ma'am.
So, right there. Otherwise, it's very easy for respondent to say infructuous and get away quietly. Lighter vein, Mr. What else can we say? One minute. 63. Learned counsel for the petitioner submits at the five. But we need cooperation from the bar, right? In not seeking adjournments in old matters.
Ready, Lordship's kindly, my lord. Item 120, 121 and 122. My lord, if your lordship so please, my lord, out of turn may be taken up tomorrow or day after tomorrow. These are 2013 writ appeals, my lord. A short point is involved. Matter arises under Inam Abolition Act.
You will have to prepare some synopsis and the counsel for respondents have to be there. Respondents have to be there.
All due respect, matters were heard and reserved for judgment for 1 year.
That will not happen. That we can 100% assure you. I have not done it in my 14 years of my career and I don't intend to do it while being here. So that's a guarantee that if this court has heard, it's a guarantee on stamp paper that it will be, the judgment will be delivered. I have never done it and I will never do it.
Please matter, that's fine.
No, but it's not necessary for you to tell because we are very sensitive about it. You are at liberty to point out any case which I have heard and not delivered in my entire career anywhere. We don't do it.
No, that's the reason, my lord, I am taking liberty to mention.
No, please do not say. We request you, Mr. not to say that it is heard by so and we don't like it. Let's say one thing that we cannot do anything about it. Number one, I was not a member of the bench which has released the judgment. I have never done it. You can find out under Right to Information Act. Any 14 years of judgeship, I have never done it. So we will not do it. That's an assurance to you. But the only thing is practical problem. It's at 120, 121, 122. You are ready because your client is after you. But what happens to the respondent? He can say that I had never anticipated.
I am preparing for respondents, but I inform my colleague.
No, but you should have made the prayer in his presence.
Ready, my lordship, so please to take up.
We will see tomorrow. You make a joint request. We will see tomorrow. If we get time, we have noted this thing. We can hear. Both of you make a joint request. We will take up. No problem.
Very well.
But we don't like this that the earlier bench released. We have nothing to do with that.
I'm sorry, but
You cannot attribute anything to us because earlier bench released. What can we do? You question the earlier bench which released. Not in good taste to a judge, to a bench which is working hard to see disposal of cases, right? Not in good taste telling a court which is deciding the cases. Which case I have to tell us beyond 1 month, which judgment I have not delivered. You tell. 3 months I have been here. Which case is reserved and heard and not decided? Which has been released? Not fair.
Anything from this.
We don't like it. At the end of these, especially when, and in the absence of the counsel, you are making a prayer.
And I have informed that.
Did you tell him? Call him. Where is? We will sit. Call him. Where is the counsel?
Tomorrow, day after tomorrow, etc.
No, but that's what we said, mister. Why jointly you cannot make this prayer tomorrow?
Very well. I'll
Jointly make it. Now this, he is not here. It's already 4:35. What do you expect us to do? To reshift this matter to serial number 1 at 10:30, right? How can we do it? Is it? The list is published. List is there are practical difficulties. So that's why we are third time we are telling you that we are ready to hear the matter provided both the councils make a prayer and we get time. Please do it tomorrow, day after, whenever your friend is there. In his presence, you make a request. Let him also say that if time permits, we will definitely do it.
Very well.